Transfer letter madam cannot see immediately.
Huh?
Motion by the transfer letter cannot be.
Today.
May I please? I'd like to mention item number 7. Matter will be taken up next week any date.
What is the matter about?
Compulsory retirement. Compulsory retirement. Any date will mean.
Why?
I have some personal problem.
Person he has been compulsorily retired. So don't you think that the matter requires urgency? The person who has been punished, he has to be.
Only in a single incident. Only a single incident.
Whatever may be, don't you think that there is an urgency in the matter?
Next week,
What?
next week, any date.
It can't go next week. We'll put it up in the month of June. And I'll put it that the council is not ready to do the matter when the matter is there.
For day after.
No, this court can't then do that. Sorry. Sure. Don't ask for an adjournment. We'll see what can be done later.
And next week, any date.
No, nothing we. Don't ask for an adjournment. Next. Yes.
I beg to mention for listing matter. One motion matter and another admission matter. Admission matter may be next week, the motion may be Friday.
Motion Friday. Admission for what?
Admission,
What admission?
pension matter, pension.
Pension.
Family pension.
Okay. 16th.
May I plead, Your Lordship? I beg to mention for listing, Lordship, on WPC, Lordship, on Friday, Lordship. Motion. Obvious.
Proposal is item 80.
Yes. Any chance of any agreement? Mr. Das? Any chance of any agreement?
Miller.
Any chance of any agreement to what I said yesterday on the last date? 1 year wages? And close the matter.
Yes, Miller.
Last time I told you, na? Didn't I tell?
So far retirement age is concerned on the last occasion we agreed.
The retirement age, no. I'm saying about 1 year wages to those persons as an out of court settlement.
Yes, I agree.
Huh?
So in this case, Miller, there are 3 workmen are involved. Immediately after the judgment, one has been reinstated.
One had died, expired.
One workman has reinstated.
The
So
family will get it.
regarding other, they may be, or they have already attained the
Age 6
age,
years.
age of 60 years on
No, it's okay.
retirement.
3 years
So
they have reached.
matter may be settled. Miller.
Huh?
Maybe settled, Miller.
Now here the family will get it. There are 3 persons.
Yes.
So therefore, with these 3 persons, what I say to them is they pay you 1 year wages. Whatever wages are there.
Yes.
In
Two
respect.
persons so far the retirement age is concerned.
What about the other one?
He
He is already working. Miller.
is working.
Otherwise,
He was terminated from the services by virtue of the award. He was reinstated. We have allowed him to work.
So then there is only for 2 persons.
3%.
So these 2 persons, they will pay 1 year wages.
Yes. Yes, that was happening. I am agreed, my lord.
Then I'll note it down and let a joint affidavit be filed. Then we'll close it on the basis thereof. It will be as if like a compromise. deed.
I don't know.
Like the same one, like that one earlier one, I got it done.
Yes,
na?
yes.
The other one, what was the name? Billwood. Similar to that, a joint agreement will be, but there were separate agreements.
Already expired, so we will not be in a position to sign. But so what the other?
No, then if one workman had expired, his legal representative will sign it.
The union is there, my lord. Union is there, union.
Oh, union, then no problem.
So then, if the union is there, so on behalf of the union, they will sign it.
Yes.
So the persons who were affected, who were the persons affected?
The Soshi Mohan Rai expired.
How many persons? The expired also will get. Why not? These are the three persons, na?
Yeah.
Shashi Mohan Roy, Muhammad Ali,
Mohammed.
and Povitra Roy.
Povitra. Povitra is working.
He's working. So Shashi Mohan Roy and Muhammad Ali.
Right.
So these two persons. So as regards the three, you have no other, there's no case out here, taking into account that he is reinstated.
Yes.
So as regards Shashi Mohan Roy and Muhammad Ali, so the union will sign it.
Yes, my lord.
1 year wages.
Yes.
Who expect? Mohammed.
Soshi Mohan Rai.
The Soshimon is concerned, his legal heir may can, so.
The legal heir will sign it,
Yes.
or on behalf of that,
Yes.
the union will sign it.
Yes.
Huh?
Not possible, then union can sign. But it will be better if the legal heir sign.
Legal here is there.
Legal heirs are there.
Legal here. Legal here is there, my lord.
There. Oh, the legal heirs. will
Union
sign
and the
it.
legal heir.
Hmm?
Union as well as the legal heir of the deceased person.
So there will be a joint affidavit filed on
Yes.
your behalf that you are agreeable to these 1 year wages. And you are also. Heard Mr. A. Dasgupta, the learned senior counsel, assisted by so-and-so, appearing on behalf of the petitioner. Mr. S. Das appears on behalf of the respondent number. Respondent numbers. Two, three, 4. And 5. Full stop. At the outset, it is submitted that the respondent number 5 is presently working, have been reinstated pursuant to the award. The respondent number 4. 4. At the outset, it is being submitted that the respondent number 4, pursuant to the award dated 10/11/2020, 9/7/2010, in reference case number 12/2009, have been reinstated and is working. Full stop. The issue involved that the challenge, the issue, the industrial dispute which arose out of the notification dated 12th of August 2009 was in respect to the question in respect to the it appears from the materials on record that the government of Assam had issued a notification dated 12th of August 2009, wherein in the schedule to the said notification, 2 questions were referred to the learned industrial tribunal, to the learned presiding officer, Labour Court, Guwahati. The said questions reads as under. Page 18 not আছে, whether the management and so and so and so and so. Full stop. The learned Labour Court, by the award dated 9/7/2010, answered both the questions, holding inter alia that the manner of disengaging all the 3 workmen from service was in clear violation of the principles of natural justice, and the disengagement orders were illegal. It was further opined that the termination of the 3 workmen, namely Sri Shashi Mohan Roy, MD Muhammad Ali, and Sri Pavitra Kumar Roy from the services was not lawful, and therefore the 3 workmen are entitled to reinstatement with full back wages. Full stop. It appears that pursuant to the award dated 9/7/2010, the workmen, namely Sri Pavitra Kumar Roy, have been reinstated and presently working with in the petitioner company. However, in the meantime, the workman Shashi Mohan Rai had expired, and MD Muhammad Ali had already attained the age of superannuation. This court, while hearing the matter, inquired with the learned counsels appearing on behalf of the parties as to whether the dispute pertaining to the present dispute can be amicably resolved. Both the counsels appearing on behalf of the parties have agreed to a suggestion, that if 1 year wage, if the wages of if 1 year wage is paid to the legal representatives of late Shashi Mohan Roy and to Muhammad MD Muhammad Ali and to the legal representatives of late Shashi Mohan Roy, the industrial dispute the award can be deemed to have been satisfied. Taking into account the above, this court is of the opinion that this aspect be brought on record by filing a joint affidavit. By the legal representative of late Shashi Mohan Roy, comma, Mohammad MD Mohammad Ali, comma, the respondent number 5 and the petitioner company as regards their amicable settlement, and further quantifying the amount to which the legal representatives of late Shashi Mohan Roy and Mohammad MD Mohammad Ali would be entitled to. How much time?
My lord,
How much time do you require for filing that affidavit?
2 months. 2 months.
Let's have it on 5th of March.
Yes.
Possible? List this matter on 5th of March 2026. Full stop. The joint affidavit be filed on or before 27th of February 2026.
Yes.
Full stop. It is observed that in the circumstance the joint affidavit is not filed, the instant writ petition would be taken up for final disposal on the next date. At 2 p. At the top of the list, huh? Top of the list. মাথাতে হয়েছে একটু মুটাতে একটু ভয় দিই। We have it on 12th.
Yes.
List the matter on 12th of February 2026 along with WPC number.
PC number 5870/2024.
Mr. Naik, this follows the judgment of Bijon Hafila.
Lordship, only.
They want something to
Yes,
that effect.
judgment has been passed. Only one issue remains, Lordship. Initially, he was engaged as works as Khalasi. Subsequently, upgraded to works as section assistant in 2000. Now, Lordship, if his post is regularized as works as section assistant, then his initial service will be calculated from 1999 only. That is the only issue. Otherwise, he will get higher pay scale, Lordship. And that is why subsequently his regularization was cancelled.
No, here the reason why I'm saying so, I don't know what he has done here. I remember the order which I passed. The order of 10/2/2006. 10/2/2000. Initially, these people were regularized.
Yes.
Now, what has happened on 10/2/2006? These regularizations were cancelled. In the case of Bijon Hafila,
Same
The-
issue is same. In that
No,
case,
no,
it
it's
is-
okay.
Yes.
in the case of Bijon Hafila, the reason for which his or her regulation was cancelled was on account of not considering a certain aspect. Now, what has happened here is, in that matter,
Lordship, in case of Bijan Hapila Lordship, his regularization was cancelled because his engagement was subsequent to 1993. That is, in that case also, Lordship, he was upgraded to the post of workshop plumber in 1999. Prior to that, Lordship, he was working as master holder. In this case, Lordship, prior to 1999, he was works as Khalasi.
No, Bijon Hafila was cancelled because it was shown that he was working as a work charge plumber only on 6/5/99.
Yes.
Whereas it was his engagement was there from 12/6/1984.
But not as works as plumber. But the post created against him is works as plumber.
Maybe,
yes,
maybe
yes.
that was the reason why it has been done, but that has been overruled by the coordinate bench have hold it that is bad.
Yes, Lord.
And that has attained finality. There is no challenge to that. Now the question here also, I don't know whether he have enclosed the entire document of 10/2/2006.
That document is with me, Lord.
You have it with you,
Yes.
na? Okay.
Yes, I have.
The reason it must be there.
Yes, the
So
reason.
we have it on 10/2 we'll have it on 12 because there are other, yesterday 2 matters are fixed and there is another matter where passed a detailed order. So that these 3 are the things and plus this one. We have it.
My only submission will be, Lordship will consider whether the benefit to be granted to him on the basis of a post as works as Khalasi or works as section assistant. Because if his continuation is to be calculated from prior to 1993, he was works as Khalasi, not works as section assistant. Now he is claiming the benefit of works as section assistant. And on that post, his service was regularized. And that is why continuation was calculated from 1999. It cannot be calculated prior to 1993. If you claim that my continuation should be calculated prior to 1993, then you have to admit that at that point of time, your service was as works as Khalasi only, not section assistant.
Then,
Then he will get the benefit as per works as Khalasi.
but he was regularized later on he was upgraded.
That is the mistake, Lordship. His regularization was in a post of section assistant. And in that post, he joined only in 1999.
So
So-
you mean to say that the order of upgrading
Yes.
is bad?
I'm not saying it's bad.
Then-
If he is to be, if he's to be considered from prior to 1993, at that point of time, he was a works as Khalasi. It was upgraded, no doubt it was upgraded. But if he is claiming that my prior service should also be calculated for the purpose of granting me eligibility for regularization, then you have to admit that at that point of time, he was a works as Khalasi, and you claim that my service should be regularized against the post of works as Khalasi.
How?
Lordship, at that point of
No,
time,
no. You see, he was work charge Khalasi. Then he was upgraded to work charge assistant. Now that is a promotional post.
no. In the works as establishment, there is no concept like promotion.
Then why is he upgraded?
So it is a subsequent, the wordings may be, Lordship, word has been used, Lordship upgraded, but there is no concept like promotion or upgradation in works as establishment.
So therefore, but is there a higher scale of pay?
Yes. If it was works as Khalasi and he has been upgraded to works as section assistant, it will be higher.
So section assistant.
Yes,
So section assistant he has been given.
yes.
Now, after his promotion, he could not have been regularized as work charge Khalasi by demoting him.
In that situation, your continuation will be calculated only from 1999 because the post in which your services has been regularized in 2005 is works as section assistant. But you are claiming continuation from prior to 1999.
No. I am not in agreement with you. Anyways, we'll have it on 12th. On that day, we'll look. List
That
this
was the
matter.
reason for department loss, I think.
No. I think we need to clarify that because he will be entitled to benefit that. List this matter on 12th along with so and so. Give the number.
I think 70, but I didn't know.
What it is?
Your working. The husband of the petitioner was removed from service. he was pursuing a matter for family pension. But as per rule 24, he now may be considered for compassionate allowance and compassionate gratuity as per rule 24. This is the case now. At final appeal, their appeal has not yet been disposed of.
That was lordship on 13/10/2025. Sir.
Something for family pension.
So appeal is pending.
No, lordship, that is, on that regard, lordship, we received the instruction, lordship. That was the source of.
They filed an affidavit, we have all filed the declaration. So PD is already completed.
What is this rule 24?
Misconduct or inefficiency. No pension may be granted to an officer dismissed or removed for misconduct, insolvency, or inefficiency. But the officer so dismiss or remove compassionate offenses and or compassionate gratuity may be granted.
And or land compassion
Profit
and or compassionate gratuity may be granted when they are deserving of special consideration, provided that the allowance gratuity granted to an officer shall not exceed 2/3 of the pension,
Okay.
which would have been admissible to him if he had retired on medical certificate. No officer, even if belonging to a class entitled to.
Which may be or lady or not to be one daughter or your daughter. They are very source of income.
Understood, but this is a pension, but does it entitle you to a family pension?
No, yes, earlier I was pursuing for family pension. Now, they may not grant me family pension. That's why I am now paying for compassionate allowance.
But why you are doing it when your husband was alive? Why didn't he take any steps for that?
Husband was alive. He
When did your husband die?
2009, you know.
So 2009, 2003, he had retired.
2009. they
When did he
expect-
retire? When was he dismissed?
I was pursuing for family pension since.
When was he
2011.
dismissed?
It was removal on 19/10/2002.
2002. 7 years he never asked for.
My husband was mentally balanced, you know. That's why the proceeding, admittedly, he was absent. So there was an inquiry, there was a proceeding, I am not telling that. So I was removed for remaining unauthorized absent, my husband. Yes, sir. I was not aware of that till alive of my husband who expired on 2009. Later on, after expiry of my husband, I applied since 2011 onwards. I applied for family pension. Now I came to learn that family pension may not be granted. That's why as per the advice, now I am claiming for compassionate allowances and compassionate gratuity. And I have also prepared an appeal, your lordship. So
30/03/2024.
let them
That-
consider whatever may be the outcome, your lordship.
That was disposal.
Now, did you participate in the inquiry proceedings? Did your husband?
From their affidavit. The lordship. After going to. They have stated that the inquiry was conducted in accordance with the procedure and instructions. I am not aware whether.
Where's the inquiry report?
Lordship,
Where's the inquiry report?
the affidavit. They have stated in para 6.
No, no, but the inquiry.
No, where's the inquiry report?
Inquiry report I am not having, Your Lordship.
Yes. Did he participate?
There will be, you can keep saying your lordship.
And tell me, Mr. Counsel, 2002 onwards, he was terminated, dismissed. You knew about it. Why? How?
I think you, I'm the wife, your lordship.
So why won't know that the husband was dismissed, that he's what not communicated to us?
So that was communicated, Lordship.
Why are you saying that?
No,
That he was not going to his office, you won't know for 7 years.
He was
from earlier, he was suffering, your lordship. He was absent from 17 to 2002. I was terminated, I was removed on 1910.
Understood. So thereafter, he for the next 7 years, he has never been to the office, you don't know. That he didn't get a single penny from the office, you didn't know. How is the house running? Tell me, for the 7 years? Unless your husband had some other properties. So from there, the income was there. No, obviously, one has to be more reasonable or more practical or prudent in that regard. From 2002, your husband has never been to his office and you don't know. From 2002, he has not got a single penny. What benefits? There cannot be any benefit in view of 24. So you got it. So you survived on the basis of that. And you never inquired how did you get that money? Done. Yes. You don't develop, I think we need to bring an end.
I was submitting representation after representation.
You submitted, you felt that the money was required only after 2 years. Your husband died in 2009. You got the money, you filed your application representation first in 2011 asking for family pension. Why? The matter has to finish today itself. Can't go beyond that. No, can't help it, but the fact remains that there has to be special reasons. Your husband did not grow. Now show me the medical certificate that the husband was suffering from mental illness. Where is it?
That was not submitted before us, Lordship. That was not submitted before.
No, let us see. Where is it? Unnecessary matters cannot go on.
Can it come on Friday or?
No, now itself.
There is some lapses on my part, but I am entitled for allowances as per rule 24 year old. That may be considered your lordship.
Huh?
There is evidently maybe some lapses on my part, your lordship.
Lapses, gross.
But
No. The thing is, Mr. Counsel, you have to understand. For this court to give you an order, this court has to hold, but to officers so dismissed or remove compassionate allowances or other compassionate gratuity may be granted when they are deserving of special consideration. How on earth would I come to that opinion? Deserving special consideration. But that is for your husband. He never applied. Man. Hello.
That's the word.
I think further tormenting your client with litigation would not be proper. We
Yes.
need to close it. Yes.
I
Ah.
am here disposed of your.
No, the reason why I'm I would have otherwise granted you, but the thing that I can't grant you this thing. And further tormenting that there is a matter pending before the court and with a hope and aspiration. This hope and aspiration has to come to an end.
And consider whether I have.
They have considered and rejected. That is what I'm saying. If they have, if that appeal was pending, I would have said so. But the appeal is also rejected. The representation has been rejected after 22 years. Like heard Mr. So-and-so. Huh?
You're on the ground of delaying it.
A delay, it's okay, but the
Let them
fact,
consider on merit your.
No, that is not.
Delay.
No, no,
Delay. Almost 22 years.
heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the respondent numbers 1, 2, 3, 4. Accountant General. Oh, none appears for the Accountant General when the matter is called. The petitioner herein has filed the instant writ petition seeking a direction upon the respondents to grant the petitioner compassionate allowance and compassionate gratuity, which her husband would have been entitled to had he been alive. And in that regard had submitted a representation dated 30/3/2024. Full stop. It is the further case of the petitioner that the said representation dated 30/3/2024 was not considered. And it is under such circumstances the petitioner has approached this court. Full stop. The brief facts of the instant case, as would appear from the materials on record, is that the husband of the petitioner, one Kailash Borman, brackets since deceased, was appointed as AB Constable with effect from 1/11/1990. Full stop. A departmental proceedings was initiated against the husband of the petitioner during his lifetime, which was registered as departmental proceeding number 12/2002 on the ground of his unauthorized absence from Police Reserve, Bongaigaon, with effect from 17/2/2002 to 21/4/2002, and further from 29/5/2002 till 19/10/2002. Full stop. An inquiry was conducted and the charges which were leveled against the husband of the petitioner was held to be proved beyond doubt. Resultantly, on 19/10/2002, the husband of the petitioner was removed from service by an order dated 15/10/2002. It appears from the very order dated 15/10/2002 that post the inquiry being carried out, opportunity was given to the husband of the petitioner by issuance of a show cause notice. But the husband of the petitioner thereupon did not submit any reply. Be that as it may, the husband of the petitioner expired on 14/4/2009, leaving behind the petitioner and his children. The petitioner thereupon submitted a representation on 3/3/2011 stating inter alia that she knew that her husband was terminated from service on 19/10/2002 and that her husband expired on 14/4/2009. And therefore, she be paid the family pension at the earliest. It is seen that the petitioner thereupon submitted various representations However, those representations did not find any favor. The petitioner thereupon learned that taking into account that the husband was removed, terminated, the petitioner was not entitled to any pension. The husband was not entitled to any pension as well as family pension. And the petitioner any family pension. And under such circumstances submitted an appeal to the Inspector General of Police Administration dated 30/3/2024, claiming compassionate allowance in terms of Rule 24 of the Assam Service Bracket Pension Rules 1969. The said representation appeal was pending. And under such circumstances, the petitioner approached this court by filing the instant writ petition. When the matter is taken up, a full stop, the materials on record show that this court issued notice on 12/6/2024. Thereupon, an affidavit in opposition was filed by the respondent number 4. Stating inter alia why the husband of the petitioner was removed from service. And that there was no medical documents submitted by the husband of the petitioner during his lifetime. It was also mentioned that the petitioner was not entitled to any benefits in view of Rule 24 of the Assam Services Pension Rules of 1969. Full stop. A reply thereupon against was filed by the petitioner. Full stop. Today, when the matter is taken up, Mr. J.K. Goswami, appearing on behalf of the respondents, have placed before this court a communication issued to the additional senior government advocate by the Assistant Inspector General of Police Law, stating inter alia that the representation submitted by the petitioner dated 30/3/2024 was disposed of, stating that no grounds exist to consider the said application. The said communication is kept on record and marked with the letter X. In the backdrop of the above pleadings, this court have duly heard the learned counsels appearing on behalf of the parties. From the materials on record, it is clear that the husband of the petitioner was removed from service by the order dated 19/10/2002. During the lifetime of the husband of the petitioner, he never applied for any compassionate allowance and compassionate gratuity in terms with Rule 24 of the Rules of 1969. There is also no challenge to the order of removal dated 19/10/2002. Till date. Pustu. There is also no medical evidence produced which should show that the husband of the petitioner was incapacitated for which he could not participate in the said disciplinary proceedings or take any further steps during his lifetime. Pustu. At this stage, if this court duly takes note of Rule 24 of the Rules of 1969, it would be seen that a person, a delinquent employee, who is dismissed or removed for misconduct, insolvency, or inefficiency is not entitled to any pension. However, on special considerations, compassionate allowance or compassionate gratuity may be granted. Be it as it may, nothing has been placed before this court which should show that the petitioner is entitled to the petitioner's case comes within the ambit of special consideration to be entitled to compassionate allowance and or compassionate gratuity. না না একটু লাইন টেনে লিখে কি লিখিলে লাস্টত বুঝতে this special consideration cannot be decided by this court. At this stage, if this court duly takes note of the document which is kept on record and marked with the letter X, it appears that the aspect as to whether the petitioner is entitled to any special consideration or not have been rejected, have not been considered. Merely on the ground that the petitioner approached the authorities by filing an application after 22 years. Be that as it may, it is apparent from the materials on record that the petitioner, since 2011, have been seeking for family pension, which have not yet been considered. It is only at a late stage the petitioner realized that the petitioner was not entitled to family pension. And under such circumstances, had submitted the representation dated 30/3/2024, seeking compassionate allowance and or compassionate gratuity. It is therefore the opinion of this court that the respondent authorities ought to therefore consider as to whether any special consideration exists for consideration of the case of the petitioner without being influenced that the application was filed after 22 years. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. The respondent authorities, more particularly the respondent number 2 and 3, are directed to consider the application so filed by the petitioner dated 30/3/2024. Again, reconsider the application filed by the petitioner dated 30/3/2024 without insisting on the question as regards delay. This court further grants further a liberty to the petitioner to provide additional documents which may permit the petitioner, which may show that there exists special consideration for the case of to consider the case of the petitioner for compassionate allowance of and or compassionate gratuity. Next. The said additional documents or representation be submitted along with a certified copy of this order within 15 days from today. Next. If the certified copy of this order as well as the said is submitted, within the time permitted above, the respondent shall consider the said application dated 30/3/2024 along with such additional materials so placed by the petitioner and dispose of the same within a period of 60 days thereupon. Next. If the respondents are of the decision that the petitioner is entitled to certain special consideration and accordingly entitled to compassionate gratuity and or compassionate allowances, the benefit thereof be provided to the petitioner 3 months thereafter. Yes, Mr. Bonik. Anything else apart from pension? Suspension. What were you granted? Let me see what is your prayer. When Mr. Bonik is appearing, one has to be double cautious. To issue order for confirmation of service of the petitioner to the rank of Imam, directing heir to grant financial benefit as accrued to the petitioner Imam for the respective retrospective promotion to the rank of so and so, dying to fix the monthly pension of the. You retired also. When? 31-3? 31-3? 2024. You retired. So your date of birth is 1st of April 2000? Ah, not prepared.
No, date of birth, I have to. 6 years, I had to calculate it.
Ah, okay.
I actually.
No, when Mr. Bonik is there, we think that he's
No.
he's like a calculator. He provides all the details like the AI.
So
Yeah.
this.
Now, what do you want here? First of all, it can't be mediated.
I'm not even paper.
No, obviously,
Because
but
this
it
is
is given out there in the column of
Yeah,
mediation.
it's-
And I am sorry to say that one thing, this mediation concept out here to send all these things to mediation does not make any sense. It is impossible. Yes, why are you replying, showing all these judgments passed by 1 to 2024? You were suspended.
That case is also over.
Yeah.
And they can reinstate.
Ah,
To the posts of assistant conservator of forest and deputy conservator of forest, I was promoted by orders with retrospective effect. These promotions were effected by creating supernumerary posts. Accordingly, notifications were issued giving me financial benefits on retrospective effect. Those financial benefits having been not released and having been not computed for my pension, I tried to do a petition. Now, the accountant general has filed an additional affidavit saying an affidavit must be issued. It will start from page 45. They say that in January 2025, 17 January, they had sought for some particulars from the forest department. The forest department has neither furnished the particulars, it's more than a year,
where? Which paragraph?
page 50. The annexed line, the last part. The last part.
Mr. Binod Kumar Payang in their affidavit have stated that upon being appointed to the rank of so and so has successfully passed the half-yearly conducted in the month of June to fulfill the criteria prescribed for confirmation in service. Upon promotion, a supernumerary post in both the cadres were created to accommodate the community. However, the treatment of the, what is this word? However, the treatment of the
Which period, the interregnum period.
interregnum period, that is so and so to so and so, is not clear to this office. So this has been sought from
It's been sought from the
Forest Department, and they have not informed. You have informed.
My lord, there is a pending departmental proceeding going on against the petitioner. So petitioner has been given a provisional pension, my lord. But and that departmental proceeding is under challenge, my lord, and has been stayed. So now only the provisional pension the petitioner is getting, my lord. Everything else, my lord, that will depend on the outcome of the my lord,
But
departmental.
that is one thing. But what about the earlier amount during the time when he was in service? Why
Earlier.
that amount is not being given? I understood about the provisional pension will be looked into. As of now, that will be recalculated. But what about the earlier amount?
But in
Are you not asking for the
This is.
time during your service? Yes, why? That amount has,
Should be done. I understand provisional now.
no, that will look into it. But what about the earlier period? When he was in service, there were some supernumerary posts being created and he was given promotion with retrospective effect. Have you given the benefit of that?
That instruction, we will need, my lord, if there's any pending arrear.
It's
in
an
favor-
old matter, 2024. We are in 2026. 1 month has gone. We are in the second month. Then
That I'll have to, my lord.
2 o'clock,
May I pray for 1 week's time, my lord? I'll.
10,000 cost. Give it to him. A person who is retired has to bring Mr. Bonik out there.
2 o'clock, my lord, I'll.
Obliged. What is the matter?
My lord, the matter is pertaining to non-release of the pensionary benefits, my lord.
Then?
Then, my lord, what happened, my lord, that PPU of the pensioners, my lord, from Bokabajan Treasury, my lord, they forwarded to our branch. I am appealing for the branch, my lord, SBI. Respondent number 10 and 11, my lord. Then what happened, my lord, in the PPU, some other documents also required, my lord, some his PAN card, ID, all those things, my lord. We wrote a letter to, we telephonically initially we contact him, my lord. Then, my lord, he was not cooperating. Then our one of
Who, the petitioner?
yes, my lord. Then one of our branch team was visited his residence, my lord, and asking certain documents, my lord, to provide us to release the pensionary benefits, my lord. Thereafter, my lord, the case was listed, my lord. Then the petitioner advocate promised that they will supply that copy before the branch, my lord. Accordingly, they have supplied, my lord.
Who is the counsel for the petitioner?
Some wrong, my lord. No.
Problem their name.
Then, my lord, what happened, my lord? We forwarded that proposal to the, my lord, Central Pension Processing Centers, my lord. Then, my lord, Central Pension Processing Center, my lord, made an objection that, my lord, that PPU, which was prepared 2 years before, my lord. So, they sought the new, my lord, one, my lord, to face the calculation of that, my lord. Then we contact that, my lord, applicant, my lord, and provide and all documents and advise him to go to meet to the Treasury Office, Bokajan, my lord, to recalculate that PPU as well, my lord. Within the meantime, that, my lord, benefit is sent, my lord, calculation then. Still now, he has not submitted that, my lord.
What you are saying, can you submit it on affidavit?
That can be, but, my lord, that Treasury, my lord, Treasury.
You
officer
are
can, my
making
lord.
this submission. You must be making the submission on the basis of
My lord,
something.
that can
Put
be.
it on affidavit.
Yeah, that can be.
Put it on affidavit.
But, my lord, in our reply,
No,
my lord,
no. Put this thing on affidavit.
my lord, I'll-
Because you see, the problem is this. All these lawyers who are there, they are not representing for the petitioner for the second time.
that's true.
Okay. Now, the thing is, if you bring it on record by way of an affidavit that the petitioner is not cooperating for which he is not given. Normally, pension matters I don't dismiss
Yes,
for
understand,
default.
my lord.
But then I will dismiss it on default in view of this, that the petitioner is not interested. But let me close it on that basis.
My-
Then let him come.
But, my lord, one thing,
But if I close it only and you inform him by way of a letter, your petition has been dismissed, then he will engage somebody and bring him. Then I'll restore it.
But, my lord, for humanity consideration, my lord, what happened, my lord, in this case, my lord, if the Treasury of Bokajan, my lord, recalculated that PPO, then we are ready to release, my lord. That's the part is there, my lord. I don't know, my lord, why the advocate is not appearing, my lord. We are the bank, my lord.
No. Advocate not appearing, I don't mind.
Yes, my lord.
I have no problem with the advocate not appearing. But if the petitioner is not helping you, not the advocate, the petitioner is not helping you for doing it,
Yes, my lord.
then how can I proceed with this matter?
That's true. But, my lord, petitioners, my
If
lord.
I pass an order in his favor, I have to pass an order thereby directing you, all of you to do the needful.
My lord.
Okay. Now, can you do it by yourself without the influence, without the petitioner helping? Can you do it?
No.
So therefore, put this on affidavit
My lord,
then I'll dismiss it. Then you come issue a letter to him that your writ petition has been dismissed, then he will do something. Isn't it?
my lord.
Ms. None has appeared on behalf of the petitioner on call. Mr. So-and-so, who appears on behalf of the SBI,
10 and 11.
submits. The petitioner is not cooperating in the, is not cooperating. And resultantly, the fresh PPO, the amended PPO cannot be made to grant the benefits to the petitioner as has been sought for. It is the opinion of this court that this very aspect be brought on record by filing an affidavit so that this court can pass appropriate directions. List this matter again on 2nd of March 2026. In the meantime, such affidavit be filed
My lord,
on or before 27th of February 2026.
oblige.
You are retired?
And some of them not yet, they're still voting. And actually their post has been created. Their post has been created, sanctioned, everything is there, but they are not getting any pensionary benefit for the purpose and not regularized for the purpose of pension.
But
So-
you have been regularized.
We are not regularized. Proposal has been put before the government. Chief Engineer put the proposal in view of the vendor species and certain all conditions have been fulfilled. But they are not entitled to pension. Most of them died without pension. And they will also die after some time. They are going to retire. They will not get pension because their service has been not regularized. They are remain as a work. Because these people were appointed after 1/4/1993. So government there is a government circular is there, after 1/4/19, no new appointment should be made. And those who are appointed after 1/4/93 and completed 10 years in 2006, cumulative basis, then they will get all the paid, regular pay scales. Accordingly, they have got a pay scale.
Getting the minimum of.
The minimum pay scale,
You
time
are
scale of
getting
pay, time scale of pay, even GPA also deducted from our pay. And subsequently, my lord, their post has been also created by special letter sanction permanent detention is also there. But they are not regularized their services for the purpose of pension. Based on pension circular also in my favor, those who are working 20 years, they will get the entitled for pension. The recent times there is a one case before the Parhatan division bench. One is Parhatan Supreme Court also pending. And one or more case, those who are contextual has been delivered judgment, dismissing the matter, contextual matter will not provide. So in view of the recent Supreme Court judgment of the various cases, this petitioner also should be.
মোৰ কালি এখন জাজমেণ্ট এটা ইয়াত আছিল ক'ত গ'ল মই থৈছিলো যে So you are getting the minimum scale of pay.
Yes,
The question is that you should be regularized.
so that I can get pen. Pensionary benefit.
Let's see the order by which it has been regularized?
Kindly see page 26.
You are giving the benefit of, yeah.
Your Lordship, kindly page 26.
Page 26 is what? Which writ petition?
Of made
Huh?
decision of item number 5,
Number,
3868.
that is your, page 26 is your prayer.
20. As directed and approved by Caribbean and District Council Authority, people by order number 27, memo number 20, employing persons are hereby temporarily appointed with workers salary for the period of 3 months only in time scale of the 20. As per. And
So these are being done by the executive officer, engineer.
Yes, executive engineer. And you
Then-
also find page 72,
Then this is appointment letter. Then where are you getting this here?
dear Lord, page 72. The Lord, charge has been given by the executive engineer, date of engagement, letter number and date, creation of the post against the person concerned, engaged, appointed and continue, still continue. Letter number, date of up to the detention, permanent detention. And total length of service.
But you were not engaged against sanction post.
In the petition, we are not sanctioned, but other item number 6, I was appointed sanction and vacant
Where?
in item number 6.
So you are getting the benefit of Upendas.
Upenda. And your Lordship will also kindly see page 64. Submission in this circular, submission of the checklist consolidated list of 10 public casual voters in connection with the High Court order 8673 in the 1422, which refers to the above, you will hereby directed to submit a proposal for regularization service of the voters.
Page 64.
Yes, 64. Process of regulation is going on in the level of the executive engineer, Ahmedabad, and as well as department.
How many petitioners are here?
Here it is Lordship.
32.
30.
Where do you get the other three?
Other three is there because those are appointed superannuated compensation appointment is also there. 2 or 3 persons.
Compassionate appointment?
Yes, Your Lordship.
Compassionate appointment is regular appointment.
Your Lordship, can you see this? Here is a certain and
No.
yes, Your Lordship, kindly page 46. As directed and approved by Caribbean Autonomous Council, Deepu Vice Letter 12 Ram Teron, son of late Long Teron, Fallacy of Division is hereby temporarily appointed to work as the inset of vacancy, place of late Long.
This is against the sanction post.
Sanction.
And that is a compassionate appointment is always against the sanction post. That is okay. But now these are the persons, no?
Yes.
So these people have joined GPF account in the year 94, 95,
Yes.
isn't it?
Yes.
98 also, some 2004. 2004 is also here.
Yes. GPF, opening, earlier opening account was not open.
Okay, but they were appointed then.
There.
Now, what has happened, information as per finance?
Page 69, here is also proposal secretary issued by Dr. Vasam. Page 69, your lordship will find. That forward in view of the following that 2013.
So they're getting all benefit. But tell me one thing. How do you get a pension means you are not being brought under the NPS? If we grant you the pension also,
NPS is from 2005.
understood, but these are of, as of now,
1994.
maybe, but you are yet to be brought within the fold of the state.
Yes.
It is only upon regularization it will be. Then how do you take care of it, the benefit of it, that you are going to be granted the benefit of the NPS? Because you can, after 1 to 2005, NPS has stepped in. How do you take the benefit of it? How can you get the 69 rules benefit?
That the government can have extra certain step regarding the issue of notification. Because there are just two notification pension we already have NSA, which that it is says that temporary person, those who are working only 10 years or 20 years more, they will also entitled to get pension. But in case if such notification is already existent there, but while regulating by such, government have to specifically mention regarding the entitlement of pension. Providing the people to close.
You will be only given the pension post here, but only the government side without your contribution. If you get it, at best you can get that. Because you see, you can't be regularized prior to that. Today, if I pass an order, okay, you regularize it and give him the benefit of the pension. After 1 to 2005, then thereupon you cannot, there is no concept of a old pension scheme is not there.
Yeah, because the past service also not counted.
And I have passed one judgment out there as regards in the old pension, new pension scheme, wherein says that once he becomes a part of the state, upon regularization, then he can give it. So how can I give you benefit of that? Because those persons also had a similar thing.
That you are going to say that done their only pension back from 2005.
Because those people were all these teachers who were in ad hoc, drop teachers and all, they were subsequently being brought in by after 1 to 2005. So therefore I say that they are not entitled to the prior scheme, they are entitled to the post. Now they are giving their contribution, some are giving contribution, some were not giving. You may at best get the only the state's contribution if somebody who has retired and who is not retired, those contributions which may happen in the meantime. That's the only way one can do it, because otherwise this will be, unless that judgment of mine is set aside. Isn't it?
Yes.
That has to be set aside. So, yes, you have a case, not only on this basis, but I can give you back to that effect from. Because the entire regularization concept came in, initially it was there, 93, you don't fall within that. But thereupon comes the 10/4/2006, 10 years prior to that. You come within that ambit. But that is again crosses the NPS line.
1,005.
So
So
therefore,
whatever benefit if I get in 1 to 2,005, then my petitioner will be selected. If their own did not contribute earlier,
they won't get their contribution. Only the state's contribution will be there.
then
Only to that. And then the pension which is there, that will only follow if these are given. Yes.
Here, my lord, final paragraph of Upendas, because petitioner has already said that they are getting benefits under Upendas, which is my lord, minimum pay scale. Final paragraph says that is for that reason, muster roll workers are not eligible for regularization and consequential benefits. My lord, several my lord petitions have been, my lord, then disposed on those lines. My lord.
But the thing is, now the law is changing. Problem arises there. After the Constitution bench judgment, it was clear. But the last 2-3 years, there is again a turmoil pertaining to the regularization. Even if you see the latest judgment of 31/2026 passed in Bhulanath's case, the Supreme Court says that no, these people have been working, this has to be given. Article 14 violation.
In those cases, my
Maybe contractual is in a more lesser footing.
but
Earlier, if you go to Dharam Singh was where these people were working on a temporary basis. Dharam Singh.
So far as Ram Singh, Lakhu, Prem Singh, Vinod Kumar, and recently Bholanath, all these cases can be distinguished. Very recently, also on Turkey, this month, earlier month, one judgment passed by board net transfer, but all these cases were taken note of. Ultimately, court said no direction can be passed for regulation of the surveys. But in that case, the court issued a direction to the government for framing a scheme.
That is also not possible in view of the District Bar Association Bandepara, where the Supreme Court says that you cannot also direct the issuance of a frame. But the problem is not that. The problem is you can only see Bholanath. Let's see Bholanath. You see what the Supreme Court says recently.
Only thing I find out, all these cases can be and based, we say that it is particular to the fact situation of that. Cannot be used as a in land law because of the findings of Umadevi judgment. You see, none of these judgments law.
You see how Umadevi says there cannot be a person taking into account paragraph 47 of Umadevi. It says that when a person enters a temporary to engage on a contractual or casual worker and the engagement is not based on a proper selection as recognized by relevant rules of procedure, he is aware of the consequences of the appointment being temporary and cannot therefore invoke the theory of legitimate expectation. Now, how does Bholanath treat it? However, the court in Umadevi clarified that the bar against invocation of the doctrine of legitimate expectation applies only to those temporary contractual or whose engagement was not preceded by a proper selection in accordance with the extant rules. Consequently, where such engagement is made after following a due lawful selection, there is no absolute bar. You see how Umadevi has been diluted here in that regard. Now kindly see limits of contractual here.
Umadevi cannot be done.
I can't, Mr. Nayak, I have full agreement with you. Umadevi is very clear. But the fact remains that now the Supreme Court is changing its trend, taking into account the more of welfare. Maybe the court has observed.
Taken by any of the judgments. The basic is lawful, irregular and illegal.
Now, if you see the Dharam Singh judgment, you see, in Jaggo versus State, this court underscored that the government departments must lead by example in ensuring fair and stable employment and involve the test of examining whether the duties here. In Sirpal, so and so, this court cautioned against a mechanical and a blind reliance on Umadevi to deny regularization to temporary employees in absence of statutory rules. It was held that Umadevi cannot be employed as a seal to legitimize exploitative engagements continued for years without undertaking regular recruitment. The court further clarified that the Umadevi itself draws a distinction between appointments that are illegal and those that are merely irregular, the latter being amenable to regularization upon fulfillment of the prescribed condition. In Dharam Singh, this court strongly deprecated the culture of ad hocism adopted by the states in their capacity as employers. The court criticized the practice of outsourcing or informalizing secure recruitment as a means to evade regular employment obligations. In the aforesaid backdrop, we are unable to persuade ourselves to accept the state's contention that mere contractual nomenclature of the appellant's engagement denudes them of constitutional protection. The state, having availed of the appellant's service on sanctioned posts for over a decade, pursuant to due process of selection and having consistently acknowledged their satisfactory year, cannot, in absence of cogent reasons, so and so.
Any numbers of judgments can be given. But ultimately, your lordship will be done. The potential value of a particular judgment and the applicability of that judgment. Lordship will not say this judgment matter, lordship will see other judgments also.
I tell you, Umadevi is 5 judges. District Bar Association, which follows Umadevi, is 3 judges. With due respect, all other judgments are 2 judges, but they bifurcate, they deviate.
But therein it has been clearly stated, clearly categorically say that only a bench of larger square can dilute the judgment path direction passing the Umadevi. So that will always remain. And lordship will read paragraph 53, last 3 lines now. Those who have been regularized. But in future, any regularization has to be considered only by following the law laid out in the Umadevi. Can that be bypassed also? That is one. Secondly, lordship, in all these judgment, lordship will get the words irregular and illegal. Lordship will particularly see the full of paragraph 21, clearly stated, if the appointment is only irregular, not illegal, then court will definitely consider this matter from at least humanitarian ground law. And if lordship again goes back to Umadevi judgment, I think paragraph 3, paragraph 11, Umadevi. But even equity, it was specifically mentioned.
But there is another judgment of Justice M.R. Shah subsequently, wherein it says that when you have taken their 30 years of their service, and then merely on the ground that you have not regularized them, you cannot debar them from pensionary benefits. That's one paragraph. You see, granting a pensionary benefits is another aspect of the matter. You see, the basis of a pensionary benefit is a welfare state. So therefore, maybe you have not regularized them. The rules may say that you have to follow 31. But would it be proper on the part to not regularize them for all these years, thereby to deprive them of the pensionary benefits?
So friends, these 2 cases are concerned. If lordship comes to that particular location of the parents department, in the first case, this is case 69. Case 69. Case 69. I mean, instruction to all the departments, by the finance department, and it is 15th of January 2025.
Yes.
But if the petitioners are claiming their appointments with made sanction, they can put. And it definitely applies to them now. Their appointment, I have seen, they have some of their appointments are prior to 1994. So they are not to do one if we are to follow one, it has to be prior to 1996. 10 years from
No, these petitioners, most of the petitioners are 1994.
now. Yes, and
they are saying that they were appointed against sanction vacancy.
No, kindly come to this particular other document is not, page 68, kindly come.
Yes.
Except 2, 3. That is item serial number 22, 23, and 24, and 27. All the others are 94 GPF account holders.
That's like, if they are workers, they will get the.
Means they are there from 1994. No, no, understood. But they have. Ah. 34. Ah.
Case cut.
Ah.
Case cut. Extra three.
Annex, sir?
Case cut.
Which petition you are referring?
3855.
No, no, the other one. I was looking into this one. Yes, Annex 3. Where page? Ah, yes. Ah,
Record number and date of creation of vote against which the person concerned engaged, appointed and still concerned. So if their appointment is against a sanction, if post were created, some posts were created, like before. So they are entitled to be considered under the paragraph 53 of modification.
no, in fact, apart from that, if you come to Robin Bay's case, you see this particular notification of the finance department.
Same
No, no, kindly come to 27/3/6/2013, Annex 8, page 58. This is as per Umay Devi. Now kindly come to serial number 2.
instructions say no.
No, understood. So here, as per number 2, who have been working continuously for 10 years or more as on 10/4/2006. That's the cutoff. Huh. Not prior to 19/4/1996. Then who have been engaged against sanction vacant post. So this is there. Who have requisite qualification to hold the post. So that is there. So these are there. So these people should have got the benefit in 2013.
Still completely doctrine and this 2025 instruction. That is, this is same one-time measurement law.
Now, understood. So therefore, this was the office memorandum. That's the policy. That is the scheme formed by the government. So when it is the scheme framed by the government, the non-consideration of those persons then cannot, because of their fault of the respondent authority for non-consideration of these people, they cannot be deprived that from 2013 onwards they should have been, because that was the scheme.
If by following this when doctrine, if their services are regularized, it will be from the date of initial appointment.
So then they will be entitled to pension.
In case of other MRN workers employees also, who were regularized in 2005. Initially, a decision was taken to grant them new pensions. But subsequently, it was converted and they were given the benefit of full pension scheme. So all the master roll and workers employees whose services were regularized in 2005 are getting old pension scheme. It was
You have that notification.
Yes, yeah. It was subsequent to February 2005. 1 to 2000. But that was a special case. I don't know what the government will do in their in the regularization or in case of regularization or not. But at least if they are claiming that my engagement was against a sanction vacant, my engagement was prior to 1990s, and I am having the qualification of holding that post, they can claim that my regularization should be considered by following this way. That should have been their prayer also, not my service to be deemed regularization or by following this. That should not have been the prayer also.
We'll look into that, whether it is there or not. But if they are entitled to, the same has to be given, irrespective of what prayer Mr. Sharma makes. You have not filed affidavit.
Not time. It was only listed once, my lord. This matter was only listed once before.
Oh, is it new, so new. Okay, I was supposed to dispose it of. Acquire finance also file. But if these people retire, then obviously we'll give them the benefit. Both these petitions have come up before this court after the initial order dated 14/7/2025, whereby notice was issued. Mr. B. Sharma, appearing on behalf of the petitioners in both the writ petition, submits that some of the petitioners are working and some have already retired, superannuated. But on account of their services being not regularized, though entitled to, the retired persons have not received their salary, their pension. Whereas, in respect to those who are presently working, they would not be entitled to the pension unless and until further steps are taken for regularization of their services, giving retrospective effect from the date of their initial appointment. The respondents have not filed the affidavit, however, submits that they would like to file affidavit. Considering the above, command lists this matter on 24th of March 2026. Affidavit be filed by the respondents on or before 13th of March 2026. Liberty given to the petitioner to file reply on or before 20 March 2026. An attempt shall be made to dispose of the writ petition on the next date.
May I please your lordship? Lordship, actually additional advocate general will appear this matter, but today he has some personal difficulties. So kindly fix the matter on another.
Who is the advocate, additional advocate general?
Take additional advocate general, take word.
As of now, you have attained the age of retirement.
The 1st January 2027. 1st January 2027. It's
You are 57 years old. What is the ground on which you have challenged?
Yes, 179.
79.
Yes, 170. This is important.
Yes.
And this is the order after inquiry matter data before the chief minister, honorable chief minister for transfer. But our honorable chief minister recommended the service of the petitioner no longer required. That's why the subsequently another order of 182. Petition will allow for the unpaid period.
Now, what is your ground of challenge?
Only as per inquiry report. There is no proof for misappropriation of money. But proof that may not due to his negligence. Proof due for his duty.
Where is your reply? Second reply?
Yes.
Second reply to the show cause notice. Hmm?
164. And second
164.
reply is 107. 107.
Now, this is against the statement of allegation. Where is your reply to the inquiry report?
Yes. Yes. 164.
100?
64.
No, this is against the first reply. Where is the second reply?
Second reply.
You see, there is, after this, this is your statement of defense. Then there is an inquiry held.
170. 170.
Ah.
Is the last. Last number 2000.
No, it is not finding against the charges. Let us see the inquiry report.
It gets
How the charges have been finding against charge. Finding against charge number 1, page 172.
yes. Yes, sir.
Yes, read it. So you knew in the operational guidelines, it was clear that if you take any action or do anything in respect to a particular work, which is not there in the list of permissible, how do you take care of it? That disciplinary proceedings would be initiated.
And that part, that
You
part,
being the BDO, you were also the program officer. So therefore, program officer and who is the overall in charge of the NREGA works and acts as a coordinator.
yes, but actually, legally is dependent on the technical officer. There is that engineer and other engineers. And they are the sole responsible at the visit Miller and here and the Miller installation of techniques signboard in this case. Miller. We do not expect that is the problem.
And you made payments without obtaining quotations.
At that time, during the COVID time, the sum of has not issued any quotation.
Huh?
Has not issued any quotation, tender Miller.
Where is it?
But as
You
per
have not replied to the charge too about anything about the COVID.
Miller, I have stated in my petition.
No, representation in your reply, you did not say anything. Did you take up that ground then? Charge number one is okay. One can hold it to be a case of negligence. You may not have it. Or charge number one, there is no details provided. Something one may say. But how do you take care of charge number two? Charge number two is very damaging for you. And what is your reply to the charge? They agree they engage the implementation has and engage the job car who are experienced and so and so. You were overall in charge. That further payments were made to the vendors selected by project so and so. Director after duly engaging so and so and fielding and so and hence the question of inviting quotation did not arise on the part of the vendor itself.
A vendor is approved by the DRDO.
Huh?
A vendor is approved by the project director.
No, the project director is, you have not given any evidence to the effect that the vendors are being done. Here, on the other hand, it is seen, kindly see from the scrutiny and say, yeah, so and so, citizens were made to a single vendor.
But there is a
Incumbent, from the provided by the incumbent PO, MG Enrega, Goripur, it is revealed that the payment against Citizen Information Board was made to a single vendor, Jahidul Islam Enterprise, without inviting quotation. It is also observed that no quotations were invited before purchase of materials by the program officer. How do you take care of that finding? Show me that the project director can allot it to some.
Here is a vendor list because I have seen it.
No, from the vendors list is there.
Approved by the DRDO. Approved by the DRDO, project director DRDO.
Show me.
That vendor list. Where the name of the rights. The rights.
Where is the Enrega rules?
Yes, 34.
Page 34.
To vendor list. Serial number 8. Died in the west.
So these are empaneled. These are empaneled.
Yes.
So these empanel, you can give it without quotation, without asking for anything.
As per version of the petitioner, as per direction of the project.
No. My question is, who places the order? You. You place the order.
Yes, place the order after approval from the higher.
No, it's okay. who is required to place the order and how? As how it is to be given is already given, that in the guidelines it is said that you have to quote, seek quotation. You have not sought for quotation. It may have been approved by the project director, whoever may be, or even the minister. That's a different thing. But you did it without calling for any quotation.
That figure, actually that figure, during the COVID period, that's why, no block officer, no development block, invite any quotation, that figure, for a small hospital. That is the person of the petitioner. And as such, the approved list by the DRDA, entrusted the whole. That figure, which statement is reflected in the report.
Then why did you choose this Jahidul enterprise?
That is not selected by the petitioner. And this list approved by the DRDA
How?
as per project director.
So the project director must have noted somewhere something.
You can interpret that.
You cannot come up with this thing unless it is written somewhere.
Yes.
The project director must have said, or did he call you up and say that, look here, you give it to him? That must have happened. So therefore, they are more considerate in only giving you the punishment of compulsory retirement.
Compulsory retirement has been as per page under 179. Negligence of the work.
So therefore, you are not efficient. No, but Mr. Counsel, are you therefore not apparent that it is not a case of dismissal, rightly so? Otherwise, if these are things where there is an allegation of misappropriation, it's a case of dismissal. Now you are going to get pension. You are going to get pension.
Getting pension.
No, you will get pension. After compulsory retirement, you will get pension. There's no quarrel with that. You'll have to, because Rule 24 does not apply to that. So you are going to get pension, having retired under the year. So you'll get pension. Therefore, the compulsory retirement is given. The basic idea of compulsory retirement is FRSR. Assam FRSR. এইখন তাত নেকি এখন নীলাখন এই নীলাখন ওপৰ এখন ফাণ্ডামেণ্টেল ৰুলছ এণ্ড ছাবচিডি ৰুলছ এইখন কি অসম নে অসম
Discipline in
Yes. Compulsory retirement, he is entitled to pension. What is the age of retirement? 58. Okay. An officer compulsory retired from service as a penalty may be granted by the authority competent to impose such penalty pension at a rate not less than two-thirds and not more than full invalid pension and special edition by if any admissible period. In the case of an officer mentioned in Rule 16 or 70 who has completed before the compulsory 25 years of compulsory will not be two-thirds and not will be in any way. So being a penalty, so there will be some consequences. But you have not raised anything about the findings. Madam, the findings do not say anything about what he has said about the project director. Does it say anything? Made by the DO, it appears the DO who was functioning as the program manager completely lacked awareness of his responsibility regarding the procurement of materials in compliance with the vendor payer. Further, he is responsible for making payment for the citizens' information despite the inquiry team fields visit revealing the absence of a single CIB at the worksite. However, during the period of personal hearing, the DO presented pictorial evidence of various works that displayed erected CIB indicating they were installed after the issue came to light. As the program supervisor, the DO failed to do his duty to uphold and protect the spirit of the Act. Additionally, as the overall in charge of all NREGA works in the block, he also failed to monitor and supervise the work implementation in accordance with the letter size remark, including financial rules. His profound lack of awareness of fundamental requirement for program officers significantly undermines the effective implementation. The deficiency clearly impacts the proper execution and success of the programs intended to benefit the beneficiary and community. In the light of the above, the charges leveled against the AI, so and so, leading to gross irregular and misappropriation of the AI in implementation of the IMA, leading to an unfruitful and unsuccessful implementation of AI is beyond doubt. Mr. Counsel, bad case. You see, these findings of facts, I can't touch it. You have not filed an appeal. So these findings of facts have to take it as it is unless you show perversity. On one hand, you are saying that the project director had directed. However, at your reply at, or more particularly at paragraph number 3, you say that the chief executive officer of the Jila Parishad asked. Isn't it? See paragraph 3 of your petition.
For other case of further.
Huh? Accordingly, as per the direction of the Chief Executive Officer Dhubri of Dhujilwe, works to be entrusted to persons whose names were enlisted in so-and-so, which was approved by CEO. As such, during that period as so-and-so, this is why you say. But on the other hand, in your reply, you say another thing. You say here that a further payment was made to the vendor selected by the Sriman after arranging and fitting here. How can you work on oral directions fit for a compulsory retirement? Yes.
It is that approved Bangalore list, there is no. With reference subject, I would like to.
Hence, you are once again directed to call a price bidding amongst the approved vendors submitted registration fees for finalization of rates. Then, this is what you did not do. If it was maintained in your records out there, that is the allegation against you. That as per the year, you will have an empaneled vendors. And amongst them, you are going to ask for quotation. Now you did not do. You said that there was nobody who was interested, so we gave it to him. How do you know? See, everything has to be done on records. That's the problem, you see. And therefore I'm saying, charge one may say so, but charge two is very difficult for you to overcome. No, I think we should dismiss it. Huh?
In this case, we not actually they have been he's engaged in this case.
Who?
Yeah. It suddenly is there is a lot. And he has asked me to mention the people teacher to push. They can't with here. That's why I mentioned at that end. We not ask for do feel both method. I cannot say method for the adjournment.
Okay.
That's why method. Very good.
এই অগষ্টখন কি ওলাই আছে হে এখন heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Ms. N. Bora, who appears on behalf of the PNRD department. The petitioner herein have assailed the order dated 26/9/2023, in notification dated 26/9/2023, whereby the petitioner was imposed a major punishment, major penalty of compulsory retirement in terms with Rule 7, Roman 5 of the Assam Services bracket Pension Discipline and Appeal bracket close Rules 1964 and Rule 56B of the FR and SR as applicable to the state of Assam. This court had heard the learned counsel appearing on behalf of the petitioner. However, it is being submitted on behalf of the PNRD department that that Mr. K. Kumar, the learned additional senior advocate general, shall appear on behalf of the said department. Under such circumstances, the matter remained inconclusive. Hearing of the matter remained inconclusive. Was to list this matter on 7th of February 2026 at 2 p.m. for final disposal, showing it as parted. But I'll dismiss it on that day. Only problem is that
Make this a lot. Okay. Dismissal from service matter, the petitioner is no more. His wife is before your lordship to protect the good name of the husband, my lord.
good name of
Her husband, my lord.
Before starting, my lord, I pray for an adjournment today, my lord. My senior relative expired, my lord, here to live for his cremation ground, my lord. Just for a day, my lord. It may come on Tuesday.
the matter of 2017. Imposition of what fine? Penalty of?
And the bank did not suffer any pecuniary loss of the money. Just on moral ground, because the image has been turned as per their allegation. That's why he has been dismissed from the. That's why it's enforcement to the allegation.
Who is your senior?
KK Day, my lord. KK Day, my lord.
The whole matter, you should not,
It will come on 10th, my lord.
huh?
10th of February.
No. Madam, what is any technical evaluation, any technical violations?
Documents which they have relied on. All the documents were not supplied to me. Even the witnesses, they said 13 witnesses will be there. Later on, they have produced 23 witnesses. And the incident which was supposed to take place, madam, from that particular place, I have been transferred to Arunachal Pradesh now. And the complainant, they have come after 9 months and they didn't go directly to the bank authorities also. If some illegality has been committed against them, they should have gone directly to the bank. They didn't go. They said they went to the TBI. And all the complainants, it's around 11 complainants are there. It's all psycho style. Same words, everything is same. Dicto, it's just photo set copy of each other. And plus they have filed a criminal case against the husband, against that expired person. And he came for bail before this honorable court. Then the complainant said, due to instigation of some interested person, I have filed this FIR. So I was granted bail. Then thereafter, again, I have filed a criminal petition for quashing of that GRC. That has also been quashed. I have annexed a copy of that order. So Lordship will find it at page 137. So this is all a conspiracy against me, my lord. Since 82, I have joined as a cashier, my lord. Then through my hard work and diligence, I have been promoted to the post of branch manager. And the incident is supposed to take place after 30 years of me joining my service. So what happened? After 30 years of me joining the service, I joined in 82, my lord. Then the incident, in 1982, I joined, my lord. And the incident, they said, take place in the year 2012 to 13 in between. So after so many years of service, after I have people, what should I do with my lord? And the bank, they didn't suffer anything. Only thing is they said their name has been tarnished by them. Nothing has been proved, my lord. There was no eyewitness. They have not produced any independent witness. Nothing, man. The person is also no more, man. I being the wife, I have come to protect his name.
It will also include you getting benefit of.
And it's quite disproportionate to the allegation. Assuming but not admitting I have done it also. Then also the punishment which they have imposed on me, it's very disproportionate.
Let's see the allegation at page 24. On investigation, it revealed that you have insisted the complainants to collect money at the rate of 5,000 each from the villagers who are interested to avail KCC loan. The amount so collected would be kept in the bank as STDR in the individual name of the villagers, and subsequently neither STDR was issued nor any agricultural loan was sanctioned to the people concerned. As per their statement, you have taken the money, but neither amount was returned, refunded, nor any loan has been sanctioned to the persons concerned. Copy of the loan documents such as application appraisals signed by them are found undated, blank, incomplete in some cases. Nature of the complaints are similar to each other. Moreover, some of the complaints submitted were Xerox copies of the KCC loan documents duly filled in and sanctioned not in official record but by you with your signature and official seal, which means that the original documents are under the custody of the complainants. Even 8 other complainants also have given their statement against you, with whom some say so and so. You thus did not discharge any duties with the utmost so and so, so and so. 7 days to reply. With reference, I have the honor to inform you that the branch office so and so took amount of these are complaints, cyclostal complaints. Where is the reply?
Just 6 minutes. Reply to the chat. Dated 1/5/2000 something. Page 50 minutes.
Where is your reply?
Page 59, and access
Page 50.
dated 1/5/2014.
Regarding the allegation, the undersigned category denies that he had made any monetary with any. The undersigned also category denies of any promises has been made to the people of Cooperative Locality for sanctioning a demand. So it will be worthwhile to mention that on the same charges and in terms letter dated in the undersigned subsequently based on reply demand. Some was based on suspension and procedure.
All the complaints on the same day, on 9/9/2013. And if you are not, you will see the complaints. That is from, type copy manner, page 26, if you're not, just see 1 or 2, page 26, page 28, it's detour, psychosalary.
The inquiry report given.
Yes. That is, from page 68 to 88.
Hey, there is an SLP file by the bank. Kindly come to page 90, annexure 12. This is dismissal. This notice is issued as an interim measure till the appeal filed by the bank in SLP is finally decided by the Honorable Supreme Court. What does it mean? When you filed appeal, what is the perversity, madam? Perversity.
Perversity, perversity is the documents. Clerk has not, all the documents has not been provided to me, my lord. Then
Where is your statement that the documents were not provided, not in the writ petition, not in the writ?
my. Yes, raise the issue, my lord.
Chalo, we'll look into it after two.
Well, finding from this. Page 21 of the inquiry report.
No. In your reply to the inquiry officer's report, there was a second so-called,
Here and submitted my case for.
no. You see, inquiry report was given, no, here you see. Kindly see annexure 9.
Yes, ma'am.
Did you submit any representation submission to the inquiry as regards the inquiry within 7 days?
Yes, my instruction is concerned. I'm not sure whether he has given or.
If he has not given, then you cannot quarrel with that.
He has given the reference to the reply which he has given on 13/10/2014, which I have shown to your lordship.
1310 is prior to that.
Prior to that.
So therefore, any document having not been given to him at the time of inquiry for which it has prejudiced him is not there. This is an afterthought in which is being brought in by way of the writ petition. That is this why the opportunity is being given to you.
The lordship will look into the inquiry report, my lord. My defense representative, whatever he has made the submission before the inquiry court. Lordship may kindly go through it.
Were you not permitted to cross-examine the witnesses?
Whatever the presenting officer has presented, my lord. They are all the complaints of the documents, all the complaints of the complainant. There was no independent witness of them. And regarding money transaction, my lord, there is no receipt, there is nothing, there's nothing to prove that there is transaction of money between the charge-seated officer and the complainant, my lord. Nothing of that sort has been proved, my lord. Everything has been done in a functionary manner, my lord. Just
Kindly come to
observing
page 72. As per the prosecution document PX1, the complainant's letter of so-and-so, it revealed that Sri Sarkar had handed over 2,50,000, collecting 5,000 each from the villagers for fixed deposit to avail the loan. And as per that so-and-so, the branch manager so-and-so told the inquiry that the so-and-so had sanctioned 30 numbers of proposals at so-and-so. The monetary dealings took place in front of so-and-so as eyewitnesses on 2 occasions. It is confirmed by Sri so-and-so that so-and-so at the residence of Saikia at Koropatia. On cross-examination made by the DR, Sri so-and-so, the proceedings dated so-and-so, noted, where is it? By DR, Sri,
complainant is produced.
where is this? The second part of this here?
Your lordship.
Made by the DR, Sri.
70.
So it is evident that the another amount of rupees so-and-so was given by so-and-so.
There's just a dual money between the complainant and the customer. They are just saying it orally. There is no document as such regarding the transaction. That's what my GR has said in the inquiry.
Like the monetary took place between the complainants with on different occasions and on different venues in the name of so and so loans we treated as proof. So very good.
And Lordship, can you see the timeline also? Why there was a delay of 9 months, my lord?
Of
Of filing the complaint. And complaint also, they have gone directly to the CBI. They didn't go to the bank to inquire what is happening. And regarding the KCC forms also, the loans, there is no proof that it was me who has given it to them. In that regard, they have not produced any document. There is no eyewitness. So nothing could be proved, ma'am.
eyewitness was there. This is what the eyewitness is.
Parties, ma'am. No independent villagers were called, ma'am. And why there is a delay of 9 months? That they didn't make any explanation. I have put up that question, my lord. But they didn't explain why there was a delay of 9 months, my lord. I had already left for Tawan in the month of January, my lord. In September, they have filed a complaint. So in between, there are other managers, my lord. Even they could have given it. So who has given it? When it was done? Nothing has been proved, my lord. And why go to the CBI first, ma'am? They have gone to the bank, my lord. The complainants, they have gone to the CBI, they have filed FIR. Then against that FIR, I have come to this high court. Then the complainant only has said, due to instigation, I have done it. So I got the bail. Then I file a criminal petition against the GR that has been quashed by this honorable court, my lord. So that conspiracy part is proved by that itself only. No doubt, even if the criminal case has been dropped, they can proceed with the departmental proceeding. But when there is some colorable exercise of power, my lord, we have to see to that also, my lord. As a per functionary manner, they have done everything. Even the appeal also, I'll come to the appeal part later on, my lord. Everything they have done it in a normal way, without looking into the allegations, whether it's proved or not. And no loss to the bank. No pecuniary loss to the bank.
No, there might not be a loss to the bank, but in the name of the bank, no, the allegations of these complainants were proved.
No,
All these complainants were present in the inquiry.
but there was no independent system. Their complainants, they were there, but there was no receipt of receiving the money, ma'am. Nothing is there, nothing of that sort is there, only their complaint. And if your lordship will just take up one of the complaint also, if your lordship will be kind enough to come to one of the complaints, I would like to show to your lordship, my lord.
Do you have the inquiry proceedings with you?
Sir, I have the Xerox copy, my lord.
Lordship will kindly come to 26, ma'am. That is one of the type complaint.
What is CSO?
Substitute officer, my lord.
Substituted officer to IA. As regards the documents, you have categorically said you have received all the documents in the inquiry report.
The inquiry itself, your lordship.
No, madam, you have to also know. You have signed it out there. Here, the PO to IA. I am submitting here with 59 numbers of documents with enclosures in two sets. One set for the CSO DR and the other set to you.
Yes.
There are 13 numbers of witnesses as mentioned in the list.
Yes, don't.
Issue not a right to submit any documentary evidence. IO to have you received the 59 numbers of documents and the list of witness? Yes, sir.
Yes, my 59 and 13 I have received. But
Yes.
they have produced 392 documents and 23 witnesses, my lord. Your lordship will see the inquiry report, they have produced 92 and 23 witnesses, my lord. I have received only 13 and 59 documents. 59 and 13 I have. What about 392 documents and 23? Suddenly from 13 to 23, 10 more witnesses and documents are from 59 to 392.
IA is who?
It's the inquiry of
No, IA.
Inquiry authority, my lord.
inquiry or
DR is departmental representative.
DA
This defense.
IA is independent. No, what is IA?
inquiry inquiring of DA disciplinary authority.
IA to PO. Please place your next witness. IA to PO. PO means presenting officer.
Then
This is so and so marked as PW5. IA, good afternoon, so and so. Answer, my father's name is so and so. Please tell the inquiry when and where Mr. Vyas signed these proposals as sanctioning in his residence. Please so and so. I had given rupees for making STR and subsequently for getting KCC loans by the applicant. Please tell the inquiry so and so. Yeah, so and so. Mr. So and so. Your is DR, na?
DA defense representative. The
Defense, my
representative is named.
defense representatives asked these questions. Question, yeah. PO2 PW. DR to I, yes, sir. You may cross-examine the PW5, IA to DR. DR to yes, sir. DR to PW. Question. Where do you work? Answer, I am a shopkeeper. Question, have you complained to the bank also? No, I have complained to CBI and local. Question, have you received any amount other than rupees 30,000 mentioned? No. My cross-examination is over. What to do? This is how you cross.
Inquiry of any seat.
What is there? Nothing is there. These people are saying, have you complained to the bank also? No, I have not complained. Have you contacted MR Saiga for refund of the rest of the money? I have visited Tawang along with Moinul to meet MR Soikia, but Mr. Soikia told that I have no money at this time. I will pay you later. My cross-examination is over. Your DR has in fact put you in more difficult position. the defense representative has put certain questions which were not even said by them and thereby got an answer. What is there? No case.
Nothing was proved.
What is there to prove? If you take, just for example, if a person takes 5,000 in cash, how is he going to prove?
But how is it?
He has given evidence that, look here, I have given 5,000 rupees to so and so. And you cross-examine him. Did you go and meet him for the money? He said, yes, I have gone him, and he said that he will pay later. There's nothing more. I have nothing to say. Tell me, how do I help you? Isn't that the proof on the basis of documented oral evidence? Madam, first of all, you have to look into it that this is not a criminal trial. So therefore, it will go on the preponderance of probabilities. So under such circumstances, these evidence categorically show that you have taken the money on the basis of preponderance of probability.
Assuming not admitting your lordship, say for example, this is. But regarding the supply of documents and the witnesses and all.
That is, you never said that.
See the inquiry report, my lord. And see the inquiry report.
Where is the inquiry report?
First of all, I would like to go in page number 71. ma'am.
Yes.
During the inquiry only.
Ah.
With your magnanimous permission, I would like to put forward my arguments against the allegations as follows. Kindly see 1, 2, what I have submitted, my lord.
All the prosecution exhibits so and so and prosecution witnesses so and so on the basis of the presiding author had treated allegation as proved are either the complaints himself or their own people who known to the complaints as evident from the statements in course of a year. The prisoner has not presented any document to prove the monetary dealings as being charged nor presenting officer independent witnesses who may have seen the monetary dealings taken place so and so. Answer, relying upon period so and so, so and so, so and so of the sanctioning authority in all the 50 loan proposals whereof Mr. M. Soikia so and so, which is evident from PEX 59, specimen signature so and so and so and so. This is also evident from the deposition of P. so and so, the present branch manager of so and so on para so and so. Then
And lord,
no case.
no, and lord, kindly see the.
Madam, enough. I think we have, this is a case for dismissal right away. More, no more, no more.
Lord, I would like to give my submission, my lord. Assuming, but not admitting that I have committed all these offenses. my lord. Then also, my lord, the bank, okay, they said their name has been tarnished. And one more thing I would just like to point out to your lordship before I make my submission, my lord. Lordship may kindly come to page 87.
Yes.
Working from 1982, my lord. Thereafter, your lordship may kindly see this second paragraph. I shall once again, after getting all these things, my lord, why?
To the fact that CSO has worked hard all along in the great organization and has commended and appreciated by the seniors so and so, as evident from the news published in Assam cover. He has the performance of his duties, never acted otherwise than in the best judgment as a person of common so and so. I pray for a dispassionate view of the whole gamut. Yes. Then?
That's what I'm saying, my lord, after getting.
No, this is what, madam, you have done it.
And then assuming that I have done it, but not admitting also, my lord, to, your lordship may kindly see from the.
It is
preliminary side
disproportionate.
whether the punishment is proportionate to the allegation which they said I have committed. There is no loss to the bank. The only thing is they said you have tarnished or name, but I have given my service for more than 30 years sincerely, with utmost sincerity. I have done my duty. So after that, just for this, whether the dismissal penalty, whether that is equivalent, whether it does not break the.
In the case of misappropriation proved, Then where is the question of anything else in a bank where there are many judgments out there?
Any laws?
No, it is not the loss. It is the name of the bank. You see, being a manager, you have done all these things.
The bank, if your lordship will kindly come to page 137, my lord, annexure A. The criminal case, everything has been closed. If something has been done by me, then I would have been punished. The Honorable High Court would not have quashed this criminal petition, my lord.
Where?
Annexure A, page one.
Where is the order?
Order, that is the order of this Honorable Court.
Where is the order of the High Court?
High Court, page 137. Last
137 is no order. Affidavit in reply.
order dated 3/8/2018.
Huh?
Order dated 3/8/2018, ma'am. I have filed a criminal.
That order is not a part of the record. Where is it?
It's
अरे अपन
there.
second copy तो दस नहीं था.
I have filed.
Huh?
In the affidavit in reply which I have filed.
Understood. Second copy to some.
Affidavit in reply which I have filed on 11/10/2018, ma'am.
Affidavit in reply.
So this order will prove there was conspiracy against me, madam. If people are there who can't see my progress and. they
Yes, what is
conspire-
this? I so and so, these are under 482, under the, it is submitted that the FIR was lost by the informant making false allegation.
And this is one of the. complaints.
Informant is present by the learned court who joined hands with the petitioner for quashing of the error. Learned counsel has taken me through the evidence of the informant recorded in Iman wherein Iman. Since the offense alleged was not of a heinous nature and the informant himself has come, I am of the view the probability of proceeding culminating in here is very bleak, as the informant has not supported here. So this is a compromise.
No, and your lordship, see, that is one of the complainant number 8, journal everything. So looking at this, your lordship can imagine, man. People could not see my progress, that's why they have conspired and done all these things, man. Otherwise, January I left, in September only they have filed a complaint, my lord.
Very bad case. Dismissal.
Lordship is bound on dismissing the case, my lord, then lordship may kindly see the penalty, please, my lord. He could have been left out with a.
On
minor
what?
penalty.
Disproportionate.
It
Why?
breaks the consent. There was no pecuniary loss, plus they have filed a FIR was filed against me, then I got bail, then the complainant has come to the court and said.
No, madam, let me give you a very clear example. You have an office, good office. Your office of Mr. B.D. Kaur and Associates is known in the state of Assam, not only there, in India. One of your associates out there keeps on taking money in the name that, okay, this work will be done and everything is done. Not from you, the money is not to come to you, but he takes the money. And this aspect is proved. Would you like to still retain him? No. Let us example. It is proved that yes, this person has taken money in the name of this associate firm, saying that this person will be doing all these things and all. In fact, you did not receive any money. Neither any money from you has been taken, but he has taken it, and thereby spoiling the reputation of your firm. Would you like to retain him?
I was listening to him, madam.
No, he has listened. That has been listened, and there is an inquiry report.
Give him a second chance, madam.
Again,
Give a second chance.
so that is why this can't be done. Chal.
At least for the wife, sake of the wife, like my lord. for-
Sorry, madam. No,
He-
I can't help you. Madam, you have to understand. You see, in a bank, these managers out there, if they do all these things, at the end of the day, there are a lot of people who have trust in the bank. These people lose their trust. This is a very important thing. And these are people who have, some money has been taken from the people, and these people in the name that they will be creating some accounts out there, or as some low agricultural loans would be given and all these things. Now thereupon he has taken and given it, he has not returned the money or something must have happened to that effect. And thereby they have filed a complaint before the CBI and all these people. The bank came to learn to know about this and thereupon had taken action. Enquiry was there where it was proved. So under such circumstances, there is nothing else to be looked into. Huh?
One last request, because
Okay.
Chief is not ready to reduce the punishment also, my lord. This matter has come in the name of the senior counsel, so let it be dismissed after he makes his submission. my lord. Just one last request I am making.
That I can do. Not at your hands. Should I put his senior counsel's name and dismiss it?
No, like, please hear him.
Huh?
And other side is also not there.
Other side, not necessary. I'm not hearing him. Not necessary. Yes. Heard Miss J. M. Kaur, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so, who appears on behalf of the State Bank of India. The present petition has been filed challenging the inquiry report dated 31/10/2014, as well as the subsequent, as well as the consequential punishment penalty of dismissal of service of the husband of the petitioner. By the order dated 19/1/2015. This court have heard the learned counsels at length and have also perused the materials on record. Prima facie, this court is not satisfied with the submissions so made. At the time of dictation of the judgment, the learned senior counsel appearing on behalf of the petitioner submits that the counsel, that a further chance may be granted to the senior counsel to appear and further make submissions. Taking into account the above, this court fixes this matter on 7th of February 2026 at 2 p.m. for final disposal.
We can let it from 9.
Number two. A final opportunity is being granted to the senior counsel to represent, for the petitioner to engage the senior counsel so that submissions can be made on his behalf. Hey, you get the entire records, including the entire thing on the next date. The Mr. So-and-so shall ensure that the records of the entire disciplinary proceedings are available on the next date. You take this. Yes, when are you going to pay the amount which he is otherwise entitled to during his service? Provisional pension will look into it.
We have received an instruction, my lord, that his confirmation, my lord, was denied. So let us bring that on affidavit, my lord.
His confirmation was denied.
Yes.
Where? You have informed him to the petitioner about the confirmation having been denied?
That, my lord,
Or have you done it recently, after his retirement?
it was done in March 2024.
March
24.
And when did the petitioner retire?
He
Of?
31st March 2024.
Did you inform, was he informed about this?
That I'll have to take instruction.
Is the copy marked to him?
Copy not marked.
One thing,
Please.
what is the notifications are concerned? They say that government is pleased to relax so and so to allow financial benefit. Subsequent demand will done compared to the notification itself.
Where is it?
34 and 38.
Page 34. Is to relax the provisions of 17(1) by invoking FA Iman to allow financial benefits to so-and-so on account of his promotion to so-and-so with retrospective effect from so-and-so.
So this is 15th of September 21.
The date of Iman, promotion by his junior Sri so-and-so in the promoted post to Iman. The date of taking charge as ACP being so-and-so. So, when he has taken charge on 19/8/2020, and thereupon he has worked as an ACP, did you grant him the benefits as an ACP then for that period?
So far as 34 and 38 are concerned, the financial benefits, we did not get, so the petitioner.
No. As per, you see, you have been given retrospective promotion from, with effect from 18/8/2000. Okay? And no, from 29/8/2009 to 18/8/2020. So this period you have been given the benefit of an ACP, isn't it? 18/8/2020 is the date on which you took the charge in a ACP. Now, as ACP, did you get the benefit of the increased pay and all?
Get back to that specific query, because we were proceeding with the petition on the premise that the benefits under the notifications in respect to the supernumerary post having been taken retrospective effect, those were not released.
So are you only on 29/8/2009 to 18/8/2020? Not beyond that?
Because the query put by the affidavit filed by the AG, it says that at page 50 of the affidavit, they put a special query of the affidavit in opposition filed by the respondent number 4. Last time, 2.
Now this is from 10/11/2012 to 13/10/2015 only.
Supernumerary 27/8/2009 to 9/11/12, and for the period 14/10/15 to 31/10/78. However, the period from 10/11.
So only question which is being made by the accountant general is for the period from 10/11/2012 to 13/10/2000 is not clear.
How they have treated it.
So that is the period, I think most probably during the period of suspension. You must have been suspended during this period. So therefore, at that period, as to whether he was on duty or not on duty has to be listed. So therefore, this aspect is another thing. But my question is, did you get the benefit for the period from 29/8/2009 to 18/8/2020, and beyond that, till the date of your retirement on 31/3/2024? So that is the question. Because if that be so, if the confirmation has been denied, this is a very important thing. Can you, who has denied? The governor?
This is a recommendation to the higher authorities by PCCF.
No, but how can you deny this benefit on the basis of this? No, because it's a notification of the governor.
That order, my lord, my lord is referring to the
Page 34.
yes, but my lord, this came subsequently, and I
So
have been,
therefore, you have to recall this order of notification dated 15/9/2021. Have you recalled it? Because he is asking for the financial benefits. These financial benefits have already been allowed. Therefore, when it has been allowed, you have taken it, you have said that, okay, we are not confirming him, it's a different thing. But can you take away his benefits, which he is already getting it, to deprive him of this notification?
34 and 30.
What 34 and 30? What is 38?
same as Deputy Conservation of Forest.
Ah. These are notifications, these have been done with the finance department. How can you take this benefit away? In 2024? A very sorry state of affairs. PHE?
Forest man.
Oh. I thought only PHE indulges in such things. Forest also does. Okay, you file your affidavit within this week. And we will take it up again on 10th.
May I pray, my lord, for one more week, my lord? Just,
So you said this week you are filing it, didn't you say initially?
yes, for proper instruction, my lord, para-wise, this week we'll get it, my lord. Then one more week just for that, my lord, pays to file it and get the vetting done, my lord, and this.
And also give the names of the officers who are responsible, huh? The interest will be paid by them. Because we are going to impose interest. A person who have been given this benefit in the name of the governor with the concurrence of the finance department, and this is being deprived now ex parte from him. Because an communication which has been given, it creates a vested right upon him. This right is you cannot take away later on. You may not confirm him. It's a different thing. Not confirming does not mean that you are going to allow him to get the scale of pay which is given as what is a ranger? No, before that. Before becoming an assistant, what was you? What were you? Before ACF?
Before ACF, my lord, ranger.
Yes, ranger. So he wants to give you as per ranger.
We have taken a stand in the petition also that whatever is required confirmation is not needed. That's.
No, therefore, when it has already been given effect to, you are a DCF from 2015 onwards. So therefore, you are to get the benefit from there. And you have worked till 2024. So one fine morning or 2 days before you, they say that we are not confirming you. This can be done. Forest can do it.
Let us, my lord, file the affidavit. my lord.
Seems to be some vindictive. Is there any vindictiveness? Huh? Something is wrong.
It is a petition.
Yeah. That is why I'm saying why a person who has been given the benefit by orders passed under the signature of the governor is being taken away just on the ages of your retirement, on the verge of your retirement.
Also have to file a petition for the leave period. Lordship was also pleased to take up the matter once when it was in roster. And thereafter they concurred to it and saying that okay, we pay the leave salary. So everything of mine has to jump the hurdle. It's almost like a steeplechase now. One after another, I have to come to the court to pay in bits and pieces. Now this part, my department proceeding was take the continuance of it. Now this part, they are now saying about confirmation. But then come up with the affidavit, eventually they also pay up.
Then they will pay with interest. And the interest will be taken from these officers. That they will mention who are the advocates, officers involved. Okay. The petitioner herein has filed the instant writ petition being aggrieved by the non-granting of the financial benefits which accrued to the petitioner on the basis of the notifications dated 15/2021 and 1/6/2023. And further, also, 6, that regularization of his pension, finalization of his pension on the basis of the notification dated 15/9/2021 and 1/6/2023. The writ petition was filed as far back as on 9/8/2024. The petitioner retired on 31/3/2024. Till date, the petitioner's pension has not been finalized. On inquiry, it has been informed that on account of a departmental proceedings against the petitioner has been only granted the provisional pension. Be that as it may, though notice was issued in the instant matter on 16/8/2024, for the last more than 18 months, 18 months, the respondents in the Forest Department have not filed the affidavit, thereby leading to the delay in disposal of the writ petition. This court also takes note of an affidavit in opposition filed by the Accountant General and the enclosure to the said affidavit in opposition, wherein the Secretary to the Government of Assam Environment and Forest Department was requested to apprise the Office of the Accountant General as regards the treatment of the betwixt period, that is, with effect from 10/11/2012 to 13/10/2015. This court inquired with Mr. I. Botakur appearing on behalf of the Forest Department as regards the said instruction, but nothing was forthcoming. This court fixes this matter again on 5th of March 2026. A final opportunity is given to the Forest Department to file the affidavits on or before 19th of February 2026. Liberty given to the petitioner to file a reply on or before 2nd of March 2026. Let the matter be called up on the date so fixed herein above at 2 p.m. for final disposal.
Problem.
Yes, what is this?
Constable in the CIA system. The state of Assam does not provide any domicile certificate.
Huh?
The state of Assam does not provide any domicile certificate. So, he was duly selected, went for a training. Then, after training and selection, for a provisional period, he was appointed, recruited, and I was posted in Delhi International Airport. I, along with, because of my Aadhaar card, PAN card, electoral card, others, I filed an affidavit and I am by documents. I am from Kachar. So,
You are from?
Kachar, Seymour, Kachar. So, there are complaints as regards the state of Assam, West Bengal, Bihar, that persons without domicile, they are being recruited in this. So, there was some physical verification. On physical verification in my area, the address given, they found nobody was there. So, I was started. But I was working there during that time in Delhi National International.
Because they posted you there.
So they terminated me. And on termination, because of the procedure, I filed an application as a sensitive part before that authority. And authority also said no, do not interfere with the order. That is why I am giving you. If they find the is annex order. Yeah, whole contextual is that. Page 94, annexure 3. This is the issue as regards fake domicile certificate. Page 95, para 6. In view of the above, it is request to initiate physical verification of the address provided in the domicile certificate of those candidates whose names are available in the attached appendix and take appropriate action against each candidate as well as existing instructed provided. This was a notification by the DIG recruitment.
So this is the basis on which this initiated the inquiry, physical.
Inquiry, and my lord,
Requested to initiate physical verification of the addresses provided in the domicile certificate of those candidates whose names are available in the attached so and so.
page 97, you will also will find regarding verification of residential status.
With reference to the, I would like to inform you the verification residential of the candidates. We are concerned with which one? Yes,
Number
Rohit
9,
Kumar,
number
so and so,
9.
so and so,
Rohit
so
Kumar
and so.
Yadav. And the last
Is
line
not
says,
residing
is not
of the
residing
above
in the above.
address as per the report submitted by the superintendent police. Okay, so he is not residing. This is given on that basis.
And my lord, then the Central Industrial Security Notification, recruitment of constable, these are the procedures. And my lord, then your lordship will find the rule at page 101, where it's number 2, it says 25(2), if during the period of probation, appointing authority in the
Where?
that the members of force not fit for permanent appointment, the appointing authority may discharge him or terminate the service from the force after issue of notice of 1 month or after giving 1 month's pay in lieu of such notice, or reward him to the rank of forfeit the different. His parent dependent as the case may.
This is probation. You are under probation.
On approach. And then termination on the page 103. Termination 103, then at page 105 is my appeal under 26(1), and the order is at page.
Okay, now tell me, okay, I've looked into this. Now tell me where, when you were posted?
My lord, I was posted. First of all, my lord, if you want to promise me, I will just test the documents through which I have relied upon. My, at page 32, 31 is a certificate for the backward class,
So, huh?
or my page 31, annexure 2, form of certificate by which shows my address at Kachar, repetition page 31.
You belong to other backward class.
Other backup plus Kachar. Then my lord, my page 32 is my Aadhaar card, address given my lord Kachar. Page 32, bottom, your lordship will find. Then my election commissions of India, annexure 33, address Kachar. Then my lord,
Then,
my lord, that page
no, where you were transferred?
34, your lordship will find recruitment of constable,
Where you were transferred?
transferred. I was posted here, my lord.
Where?
This is when, well, there, you can order itself will show, my lord.
No, you were there. To
There, my lord.
how do we know?
But your lordship will find, my lord, your lordship.
Ha. The deputy inspector, yes, Iman Tamni.
Constable formal, yes.
Temporarily appointed in answer for it.
Page 1,
Okay, so this is here.
Page 112, first paragraph. Rohit Kumar,
Page?
second line. Here is it,
Page 48.
112.
Why should we go to page?
Because
So
this
you
is
have not,
shows that I've been
you have not enclosed the termination.
My lord, permission order is there, my lord, because that is the order by their department, which shows that I am in New Delhi. Page 112, first paragraph. Disposal of the representation dated ex-constable Rohit Kumar, you the formerly of CISF Unit 1, Indira Gandhi International Airport, New Delhi, against the order of termination of such and such. CISF All India, Indira Gandhi International Airport, New Delhi. They admit that I was in New Delhi. That order of Malan appeal, page 112, first paragraph. And my lord, page termination.
Okay,
order,
okay,
page-
now tell me, Mr. Counsel, you have received the additional, you have got that from the SP. Isn't it?
Yes, the physical verification.
The physical verification, where is that the document
Page
again?
number
Yes,
97 of the.
page 97.
Yeah.
Page
Got from ADC
97,
And
isn't it? You are there for whom?
For DC 5 and 6, ADC, I can.
What is your stand?
We have, after receiving the communication from CISF, we have conducted an inquiry and SP, as per our instruction, and on the basis of the report from SP, additional district commissioner states that he was not in resident of that location.
He is not a resident of that means, on what basis do you say that?
Here it is, on receipt of letter from the CISF authority, the residence status.
Where is the letter of the SP? Verifying?
That is not here, Lordship, not annexed. SP report is not there, Lordship.
Madam,
is
both
a-
of you
we can try
interchangeably, both of you keep on interchangeably appearing for the state of Assam and the central
I
government.
am in this
No,
particular.
wait. So therefore, my question is now, where is the document of the SP? Which categorically said that he is not there. He is not there at that moment is different from saying that he is not a resident, taking into account that he has an Aadhaar card,
Yes,
taking into account that his Kachar certificate is there.
yes, Lordship.
The OBC certificate is of importance. It's a statutory certificate. Don't you think so?
Yes.
Then, did you look into all these things? On what basis do you come up and say that he is not a resident? The additional deputy district commissioner? Do you think that it is so simple?
Yes, Lordship.
He
that
has his
report-
properties there. Does he have properties or there? Then
My documents are there.
he's an OBC. OBC?
No,
OBC?
page 31. Other record files. Page 31.
His certificate is issued by the deputy commissioner.
This is certificate is there, Lordship.
Have you looked into his certificate?
Yes.
Is it fake?
OBC,
Madam, page 31. Is it fake? You can't issue a certificate
yes.
of OBC certificate by the additional deputy commissioner and say later on that look here, this particular certificate is wrong. Unless you say that this certificate is fake. Here it says it belongs to area so and so of village so and so Kachar is community area is recognized as a backward class by the government of notification and so in the district, and this is to certify that he does not belong to a creamy layer. This is a certificate given on, what is the date?
It is not.
Where is the first page of this document?
Little 11, 12.
Huh?
No,
11/12/2000?
no, not mentioned here.
Now this is given for a particular period.
Yeah.
This creamy layer is not given for all times to come. There is a date. Have you looked into the authenticity of this certificate, madam? Getting the Aadhaar card is very easy.
Yes.
And election commission is also easy. But the question is whether you have looked into the date. Why? What is the date of this certificate? Mr. Roy Chaudhary? Not prepared properly.
It is known as 10/3/90 Employment Resolution number dated 10/9/1993. In the middle of that certificate, something. Employment resolution.
Mr. Roy Chaudhary, you have not prepared properly. 10/9/93 is a resolution of the central government. So therefore, this certificate is fake. Because this creamy layer certificate is given for a year. Where is the year?
Here is not.
Huh?
But Malad, my only question is that. when
You do one thing, you verify this certificate, the authenticity, and submit an affidavit on two aspects. Whether this is there, and secondly, as regards what is the basis of how the inquiry report was conducted by the and bring the SPH letter, okay, and how the inquiry was conducted. Okay. Because it is very strange. This certificate is strange.
I don't find one thing is also there, it is handwritten. Handwritten.
The handwritten is also because you see recently these certificates because you were appointed pursuant to in Dano where
Well, that
the recruitment made when
11/11/22.
22. 22, have you started giving this computerized the form FAD?
22, that
Huh?
instruction.
Nowadays it is given
Yes,
computerized
this is now computerized. At that time,
because he
I
did
have
it
to
in
find
pursuance
out.
to a position filed in here where you were appointed pursuant to
Page 34.
no, we look into pursuant to
11/11/22. 22.
you were appointed in 2022.
Yes, Lordship.
22. Where's your appointment letter?
Page 34.
30.
11/11/22.
You were put nearby to airport. Hmm. Oh. Heard Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. C.K.S. Burwa appears on behalf of the respondent numbers 1 to 4. And Ms. S. Burwa appears on behalf of the respondent number 5 and 6. The petitioner herein is aggrieved by the termination of his appointment by the impugned communication dated 4/10/2024, as well as the dismissal of the appeal filed by the petitioner. The ground on which the petitioner was terminated is that the petitioner had submitted a fake domicile certificate that the petitioner is a resident of village Dudpatil, Lamargram, Part 6, Post Hatichara in the district of Kachar, Assam. it is very pertinent to take note of that the said termination of the petitioner is based upon a communication issued by the additional district commissioner, Kachar, dated 2nd of July 2024, wherein it is stated that the petitioner, along with various others, were not resident of the above address as per the report submitted by the Superintendent of Police, DSB, Kachar Silchar, by letter dated 24/7/2024. Pustu. This court finds it very pertinent to take note of that on one hand, the additional district commissioner, by the communication dated 2nd of July or August, or 2nd of August, 2nd of August 2024, had submitted the said verification report. And on the other hand, that the same district office, said officer, the said office had given a certificate on 11/12. That's year not known. That the petitioner belongs to the OBC Gwala community, which is annexure 2 to the writ petition. This court further also takes note of that the respondent number 5 is the district commissioner Kachar, who is otherwise also the district election officer of the district of Kachar. The said respondent number 5 shall also verify and submit a report before this court as regards the authenticity of the Election Commission of India identity card enclosed as Annexure 4 to the writ petition, wherein the address of the petitioner have been duly mentioned, and more particularly as to whether the petitioner's name appears in the voters list of 115 number Udarbond General Legislative Assembly. This court further takes note of that the respondent number 1 is the Union of India. The authenticity of the Aadhaar card, which is enclosed as Annexure 3, wherein the petitioner's address is being mentioned, can also be verified. This court therefore directs the respondent number 1 to make a verification and submit a report in that regard. List this matter again on 10th of March 2026. The respondent number 5 and 6, and the respondent number 5, the respondents are directed as hereindunder. Number 1, the respondent number 1 is directed to submit a report as regards the authenticity of Annexure 3 to the writ petition, that is the Aadhaar card issued to the petitioner bearing number 9028-3175-1326, and as regards the address contained therein. The respondent number 5, who is also the district election officer of Kachar, is directed to verify the authenticity of Annexure 4, that is the Election Commission of India iCard, and more particularly as to whether the petitioner's name appears in the voters list of Udarband General 115 Udarband General Legislative Assembly in terms with as mentioned in the said Election Commission of India iCard, and submit a report. Number 3. The respondent number 6 is directed to verify the authenticity of Annexure 2, that is the OBC certificate which have been issued in favor of the petitioner. And further, also bring on record the communication by which the Superintendent of Police had submitted the report dated 24/7/2024. The respondent number 6 shall also state in the affidavit as to whether any further verification was carried out apart from the communication they issued by the Superintendent of Police, Kachar Silchar, dated 24/7/2024. List accordingly.
Aadhaar card has been issued by Ministry of Electronics and Information Technology, Lordship.
So what? Union of India can do many things. You have Union of India. I've never said. So you do everything and find out as regards the authenticity. You can very well get it done and find out authenticity as regards the address. Because what happens is that nowadays, if you come up and say that yes, the address is Aadhaar card address can be made fake, that's your lookout. That you doing at the risk of.
That database has to be done.
Because his Aadhaar card contains an address. Check it out whether it is or there or not.
Yes, everything has been linked.
Now, you see, one big problem which I see nowadays everywhere, these Aadhaar cards are given, or addresses in the Aadhaar cards are also contain some temporary addresses also, which is very normal in Delhi, as I could see. That day I met somebody, I said, your address, what is your permanent address? The permanent address is not there. Some rented accommodation address is being given.
Yes.
So therefore, this collection of address may not give the proper identity or in the Aadhaar card. But as regards the Election Commission's iCard, as the DEO, he can very well verify with the CEO as to whether his name is there in the voters list. If his name is there in the voters list, he can very well say that yes, he is a domicile. Because there, his name is given against a legislative assembly, 150 Uttarband legislative assembly. And as regards the OBC certificate, I'm very surprised why it does not contain the last two. It should contain the date.
It was given, year was done.
So it is not known as regards the authenticity. Now, if he doesn't have the OBC certificate, if it turns out to be fake, then otherwise also his job goes.
Before losses take how many? Maybe it's a bench to matter. Bench to matter. Because it's involving the SSA, Education Department.
SSA?
SSA and Education Department.
Oh.
Earlier, therefore, pass the order, whether it is dash 2 or 3. This is the order, my lord.
From other cases, from other cases, my lord.
Same department. Therefore, mention.
You have been transferred from?
My lord, Kalinga block, Walpara to Chief block, Chirang, my lord.
Please 13.
Included is starting.
So what is your problem?
My lord, the petitioner, the medical person, my lord.
Huh?
Only medical government.
44 years, what is the problem?
Because he's saying
Medical grounds, there is nothing else.
I have enforced all the medical records.
Huh?
70 years old, old mother, my lord. Schizophrenia.
Sirang is nearby to Gwalpara. To come to Apollo, isn't it? Yes.
He is sick.
You are
sir.
showing it in Apollo. You are showing it in Apollo and in Kamrup. Sirang is nearby. It will be easier for you. You are not showing it anywhere.
They got it.
My mother, my lord, I have.
Huh? You are permanent resident of that place.
Nija, my lord. Nija come.
So Mirza, but you have been transferred from where? Gwalpara to Sirang. Then Sirang is nearby, isn't it?
My lord, more than 43 kilometers, 143 kilometers
From
from Nija.
Mirza
Yeah.
and Gwalpara.
Walpara 100.
So 43 kilometers hardly made a difference. No case. No, 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 no.
And my sister to
Hometown. My goodness, are you staying from you are doing your service from hometown? From another district? Are you saying that? Are you saying that?
No.
Then withdraw. Okay.
the petitioner also submitted a representation.
A representation, they will consider, that's a different thing. I'm not going to say anything to that effect. Representation is nothing. You have given it to them, they will request you, they may consider anything. But I'm not going to say anything to that effect. No, they may consider, not consider, that is their lookout. But the fact remains that this does not appear to be a good ground for interference within the limited scope available under Article 226. And from 2012, 14 years you are there. You have made your home, Gwalpara. But you have place out there at Mirza. You show it out here. No problem. Chalo, what do you want to do?
Number 2, which was a minor representation.
That is their lookout, whether they look at it or no. But if I pass an order, I will hold it that there is nothing on. Thereafter, they will say it will be up to the AR to consider or not to consider. That is their lookout. On administrative exigency, whether it's, but you cannot be there for 12 years. You have already there for 12 years and thereupon being transferred. Isn't your post transferable? Then what to do? Dismiss. Dismiss to dismiss. whether you want to go without the word dismiss or you want to go with the word withdraw. There are two things. Or you want to say that let me try my luck in bench two.
It will be taken on next week. I have to take it for my time.
You sought for a permission for moving an unlisted, and now you seek for 1 week. The order, the moment I pass that order, then immediately the matter will again come back to me only. Isn't it? He should have first agreed to your suggestion.
Yes, my lord, bench two,
Huh?
bench two, straight away.
No, this is a case for dismissal right away. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 1 to 4.
My lord, I appear for 2, 3 and 4.
Appears for the respondent number 2, 3 and 4. Full stop. Taking into account the order which this court proposes to pass, comma, this court dispenses with the notice as regards the respondent number 5 and 6. The petitioner herein is aggrieved by the order of transfer dated 22/1/2026, whereby the petitioner, who is the block MIS coordinator and presently posted at Balijana block of Gwalpara, was transferred to Sidli block of Sirang. The ground on which the petitioner have challenged the transfer order is that the petitioner is of inconvenience on account of medical ailment of himself and his mother.
Mother and sister.
Huh?
Mother and sister.
Mother and sister, and of himself and his family members. Your mother stays where?
70 years.
Where?
Major.
And sister?
Also along with.
It is an admitted fact.
Any other sister.
Sister is in Mirza.
Yes,
It is an admitted fact that the mother of the petitioner as well as the sister are residents of Mirza in the district of Kamrup. Metro, na?
Metro. Well, well, he says it's real. I don't think it's real.
Major is well.
Major is real.
Of Kamrup.
Kamrup, man.
Full stop. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner resides at Gwalpara or Mirza, taking into account that the petitioner is was appointed as the block MIS coordinator at Balijana block of Mualpara. The learned counsel appearing on behalf of the petitioner submits that the petitioner for his work resides at Gwalpara. But it is easier for him to reach Mirza, taking into account that the distance is shorter than that from Sirang. Full stop. This court have also taken note of that the petitioner was transferred to the Balijana block Gwalpara in the year 2012. And the last 14 years, the petitioner is in the said office. The materials on record, as well as the submission of Mr. Esbora appearing on behalf of the respondent number 2, 3, and 4, show that the petitioner's post is transferable. Considering the above, this court, however, does not find the present case to be a fit case for entertaining, taking into account the limited scope of judicial review in respect to a transfer being made in administrative exigency. Full stop. Accordingly, this court therefore dismisses the instant writ petition. Full stop. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not affect or prejudice the petitioner. In considering the representation so submitted by the petitioner before the respondent number 2,
Page 14.
full stop.
May it please your lordship. Lordship, in this matter, I am seeking accommodation for today, my lord. As we have misplaced the brief, my lord. We have misplaced the brief, my lord. We require some time to reconstruct it. My lord. Any date next week, my lord.
This case was admitted by Justice Rishikesh Roy.
Yes.
This judge has become a Supreme Court judge and retired, but the matter has not finished.
Seeking accommodation for.
And the file must have been misplaced, taking into account the long passage of time.
I'm paying for today's accommodation. I pick the matter this week also, Friday.
We can't. Okay. The counsel appearing on behalf of the petitioner seeks for an accommodation on the ground that the file has been misplaced. So the instant writ petition is of the year 2017, and almost 9 years have passed by. So getting an opportunity to get the matter resolved. This court, taking into account the said aspect, adjourns the matter to be listed on any date as may be convenient to the parties upon application being filed jointly by both the parties before the registry.
Second, 10 to 12.
Whose case was bad?
My colleague's friend was, my colleague, Mr. Chaudhary, his case was a little bad.
I asked him to find out something.
Yes, I believe the officers are present. He must be, I've just asked another colleague to inform him that this matter has been called
Okay.
up.
Now, the question which was there, if I'm not wrong, is that during this entire period, what is the basis for having it calculated for the last 12 months? Because the maximum period is you can calculate is of 12 months. And when that too, in the MDA, that meter concern, you can very well find out when there was use of electricity more than what is the sanction load.
Though my friend Mr. Chaudhary
Yes,
is aware
Mr.
of the
B.
matter,
Chaudhary.
what they have, in a nutshell, what the officers have informed me is
Mm.
that this meter perhaps cannot read that entire amount of electricity that has been unauthorizedly used. What the officer has informed us in a nutshell is that the meter which is used, it cannot read the entire amount of electricity which has been unauthorizedly used. So that is what I have
A
understood.
meter can very well know how much it has been used.
What is the regular usage?
What is the regular? Whether it goes beyond the sanction load. Where is that order? That passed by here. In this rows. Yes, here. Upon hearing, it appears that both the parties are in agreement that for the purpose of arriving at the demand charge in the case of excess load so-and-so, the provisions of so-and-so would be applicable, taking into account that the same is reproduced herein under. Demand equals to demand. From the perusal of the formula mentioned for arriving at the excess demand in case of excess, it seems that the various variables have been taken into consideration. This includes the determination of the total connected load detected at the time of inspection. This has to be multiplied with the period on the detected load and further multiplied by the number of months. Really taking the account of the fact. This would be during the course of the inquiry with the learned study regarding the implication of the numerical ends in the same formula, in as much as it promotes the number of months, one duly takes into account the fraction of the month. The learned standing council submitted the period of unauthorized use of the electricity cannot be ascertained. Such periods shall be limited to a period of 12 months immediately preceding the date of inspection. This aspect can be found in so-and-so. This could have given an anxious consideration in Iman and the words used therein at the period during which the unauthorized use of electricity cannot be ascertained. Then only the period shall be limited to 12 months immediately preceding the date of inspection. It also implies that for the line 12 months period of be justified in nature of why the period of uncertainty will be certain. Therefore, rising in the electricity provided to the additional ritual operation during the particular to certain the connected load. Materials and cost suggestion is possible, as much as for people of the various fields produced before this conflict. Yes, let us take rose candy. Rose candy. Yes, tell me.
My lord, Mr. Antanu Bose, my lord, he is the DGM Commercial APDCL, my lord. He is here to assist lordship, my lord, as regards the queries raised.
Very good. Let us also be enlightened. Yes, tell me. How do you do it?
My lord, so far as the recording the total connected load in the electronic meter is concerned, so the basic working principle of the electronic meter is whenever it gets the input, then it records it. So suppose we have 10 number of machines connected in the network. So whenever one machine is put into use, so that will be recorded, readily cached by the meter. The ampere it will record and the ampere will be converted into kilowatt. So this is the working principle of a meter. And my lord, in 2007, there was an amendment through which this contract demand has been implemented in APDCL. So prior to that, the connected load converted into KVA. So that was the basis for calculating the fixed charge. So in 2007, newly that contract demand concept was introduced, wherein a consumer has been facilitated to provide his load requirement as per his actual load requirement. He can execute an agreement with APDCL.
Just for
separate-
example, he may ask for 10 kilowatts or 15 kilowatts, whatever it may be, he may ask.
Yes, yes, my lord. So, so there are basically three parameters: sanction load, connected load, and contract demand. So these all are separate things, separate parameters. So that means the connected
So
load is the
there are
total.
three parameters.
Yes.
One is sanction load.
Yes, my lord.
Sanction load is the load by which what is sanctioned in the agreement, isn't it?
Yes, my lord.
Sanction
At the
load.
beginning, when the
Then
consumer.
connected load. Connected load is the load which is presently connected.
Yes, my lord. Physically connected to the APDCL network. So that
APDCL.
has to match with the sanction load. When a consumer is connecting his load to APDCL mains, so he has to take care of the fact that so that it does not exceed the sanction load, which is sanctioned at the very beginning of the procedure of
Just for
releasing the.
example, in this room out here, the connected load is just for example, take it at 10 kilowatts. And what is to be connected out here? Just for the example, the AC is there, these ACs are there, all these fans and all, should not be more than 10 kilowatts.
Yes, the sanction load.
No, the sanction load is there. Sanction is 10.
Yes.
And these lights which have been, or fans which have been issued along with the AC cannot be more than 10 kilowatts.
So,
Because the sanction load is 10 kilowatts.
Yeah, yes, my lord.
So that's
Yes.
connected, which is being connected. These are all connected to the APDCL network.
Yes, my lord.
So therefore, this cannot go beyond 10 kilowatts.
As per rule.
Yes. Okay. Then what is the contract demand?
Yes, my lord, contract demand when this concept was implemented. So this concept was for the HT consumers, high tension consumers. So it was introduced with a view to facilitate the consumers to submit their actual requirement of load. Suppose, for example, suppose in a house, as you said, my lord, 10 kilowatt load is there. So if you convert it into kVA, you need to divide it by 0.85. So say it is 13 kVA. So 13 kVA. So, but 13 kVA at a time, one consumer usually does not use. So his actual requirement is 5 kVA, suppose. So he can execute separately a contract demand with APDCL that I will not use for more than 5 kVA at any point of time. So this is the
This
separate
is the contract demand.
contract demand.
So this is irrespective of the sanction load.
This is, but it has to be.
If I may formulate, it is irrespective of the sanction load or the contract load, connected load.
It is
a person can, a consumer can very well have an agreement with APDCL and say, that look here, at any point of time, my load, although it is sanction load or the connected load is 10 kilowatts, but I would not use more than 5 kilowatts.
Yes.
That's the contract demand.
Yes, yes, my lord.
Okay, then.
So a separate contract demand agreement needs to be executed with APDCL for that. So apart from executing the model supply model agreement, which is called as model agreement, apart from that main agreement, one separate agreement has to be executed with APDCL. So then while using load, the consumer has to keep this in mind that anytime he exceeds that 5 kVA while using his load, so he has to be ready to pay the penalty, overdraw penalty.
Beyond the contract demand.
Beyond the contract demand. So that was my lord.
Irrespective of he having a higher sanction load.
Yes, he has, he will.
No, his sanction load is 10.
Yes.
His contract demand is 5.
5.
But tomorrow, while at any point of time it becomes 7, you say that for these two,
he will have to pay the overdraw
penalty additionally.
Yes. Yes.
Penalty for these two.
Yes, my lord.
Then.
So this is the overdraw penalty, and there is another thing, my lord, which is load survey. So while we visit one consumer premise for load survey, so point by point we calculate all the accessories or loads which are connected to APDCL mains. So the rated capacity basically is taken, and then we add this up, sum this up to arrive at the total connected load figure. So if we see that this total connected load is exceeding the sanction load, my lord, sanction load, then we penalize the consumer.
So that means you look into each of the switches
Yes,
and the appurtenances
yes, yes, my lord.
which are connected to the ACB line. And thereupon, if you find that it is more than the connected load, sanction
Sanction
load,
load.
you penalize.
Yes, yes, my lord. So these two are separate things. Overdrawal penalty is a separate thing
But
because,
how do you do it for 12 months?
my lord,
How do you do it for 12 months?
assessment bill.
Yes.
Actually, so while raising the assessment bill, we take utmost care, my lord, to find out the actual date of occurrence. So, but in many cases, it becomes it is not possible for us to trace that particular date because because the meter itself is unable to detect the total connected load, my lord, because the consumer always, HT consumers basically, they always execute a contract demand agreement with APDCL, my lord. So as I told you that that contract demand will be on the lesser side. That means it will, if the total sanction load is 10 kilowatt, his contract demand is 5 kVA. He will always try to avoid that overdrawal penalty. So for which he will, while using the load, he will always try to remain within that 5 kVA. So there are very less chances that he is going to use 10 kilowatt at a time. When, my lord, he will use 10 kilowatt at a time for 30 minutes continuously, then only that parameter will be catched by the meter. So this is the thing due to
So
which,
then if he is doing it only for 30 minutes, why you are claiming him for 12 to 1 year?
my lord, that continuously for 30 minutes.
Then only it catches.
Yes.
You say because of the fact that if he works for 30 minutes together,
Yes.
beyond the contract demand, then it will be reflected in the meter.
No, my lord, I am saying that if the 10 kilowatt, suppose his sanction load is 10 kilowatt, suppose he has additionally over a period of time, he has gradually added some loads to the network due to which his total connected load now becomes 14 kilowatt, say, let's say. So that 14 kilowatt, if he uses at a time for 30 minutes continuously, then only it will be recorded in the meter or otherwise not. But consumer generally does not do that because if that is once recorded, so he will have to pay overdrawal penalty. So consumer generally tries to avoid that overdrawal penalty. That is why though his total installed capacity is 14 kilowatt he is using, but he will use it part by scheduling it so that at any moment he does not exceed that 5 kVA contract demand which he has executed with APDC. Once he, because he knows it very well that if he exceeds that kVA, then he will have to pay the overdrawal penalty too. So another thing is that, my lord,
GM, kindly appreciate one thing. All understood, but why the 12 months? Is it because of your inefficiency or lack of manpower?
12 months, my lord, 12 months, we always, we have other options too, like the purchase, suppose the extra machineries which we have detected at the time of inspection. So we ask the consumers to submit the purchasing details when it was purchased. So from those documents also, we can at least make an attempt to, find out the actual date of when
So
these loads have been connected. So
therefore,
those options are.
therefore, Mr. GM, therefore, you have to note it in your assessment bill that we have tried to find out these and these were not possible. And therefore, we have found out that we are putting 12 months. You see, you are applying 126.5. 126.5 is the outer limit. 125.65 says they beat it at me, whatever heavy. You may have lack of manpower, everything, You under no circumstance, the petition, the consumer may for 2 years, 3 years, he may continue, but you have to limit it for 1 year. The reason is because of your inefficiency or lack of manpower, the consumer cannot be penalized for more than 1 year. That's 126.5. But the question is, when the variable of n, which is there in clause 7.2.4. Roman 3.1, stays about number of months duly taking into account the fraction of a month, which is as per the regulation. Are you not therefore required to make an endeavor in your assessment bill that look here, we tried our best to find out, we have these documents which suggest that for the last 12 months or more than that, this person concerned is using this. And with this connected load, we find that this is it. Without that, on what basis can you come up and say that look here, this has happened? More so, when in the case of this Rose Candy, there's a bill out there which is being given. Where's the bill?
646, that page, my lord, 80 onwards.
80?
80, 81 and 80.
78? 80, 80. Yes. Kindly come here. 80. Meter reading. Demand fixtures. Total demand. Charge electric overall penalty. Penalty is given somewhere. Where is that, Mr. Sakia?
Last table, my lord,
No, last table, where it is given?
energy charges, 23.
Penalty. These are penalties being imposed. Units 43760-20825, so and so. Power on hours, so and so availability. But I saw something, I forgot. Current charge, gross, not amount. Somewhere there is additional amount being put.
My lord, this is mentioned that overdwell penalty.
Overdwell penalty, yes, that is there, 7,735. How do you, where is that basis on which you are finding this overdwell penalty?
My lord, I have stated that the maximum demand as recorded in the meter, my lord.
Where?
Mentioned, my lord, in the middle of the middle table, my lord. That
Maximum demand, KVA, 496.
yes, my lord.
What is RD?
Yes,
RD is?
the recorded demand, my lord.
Recorded demand is 050, maximum deviate 496. BD means?
Billing demand.
Billing demand is so and so. Now, unit so and so, penalty so and so, this is it. Power on hours. Now, how, Mr. GM, how are you finding out this overdrawal penalty every month?
My lord, overdrawal penalty is based upon the recorded demand in the meter, which is shown by the meter. So,
Recorded
for
demand means-
example, my lord, in this particular bill, the recorded demand is, as you can see, it is 0.5.
0.5.
So 0.5, yes. So this 0.5 has to be multiplied with MF, multiplication factor. So multiplication factor is 1000. So 0.5 into 1000 means 500. So that is the recorded, in this manner, the billing demand is found out. So that billing demand, whenever the
No, first and foremost. This overdrawal penalty which is being imposed is for what?
exceeding the violating the contract demand agreement.
Means a
my lord.
person can very well use. Just for example, a person has a sanction load of 10 and he has a connected load of 10.
Yes.
If he doesn't have a contract demand,
Hmm.
some people may not have a contract demand,
Yes, yes, my lord.
then he may very well use this particular 10,
His billing demand will be, my lord, then 10 kilowatt. That will be his
10
billing demand.
billing demand will
Billing
be 10 kilowatt.
Yes.
But how do you get it more? If just for example, this has only connected 10 kilowatt of all the apartments here, and the total connected load, sanction load is 10.
Oh.
This room normally consumes up particular points, certain units of electricity, taking into account that it works from 10 to 5. But just for example, this person concerned, he puts on this light and goes away. And for the next 30 days, it is just running. Units may be more. Now, how do you find out that this is more, there is an maximum demand for overdrawal penalty means what?
Overdrawal penalty means, Your Honor, there are two parameters that I already have stated, that one is sanction load or load, and another one is contract demand. So connected load, like I said, 10 kilowatt if is the total installed capacity of a premise. So that will be the connected load. So when a consumer is opting to avail contract demand agreement, so he will always demand that, okay, although I have a 10 kilowatt load, but I will at a time I will use only 5 kilowatt, not more than that. So he will separately enter into an agreement of contract demand. So overdrawal penalty is when you violate that agreement.
So therefore,
Contract demand agreement.
therefore, overdrawal penalty is when you have a contract demand agreement.
Yes.
So there has to be a contract demand agreement, then only you can.
Yes.
Okay. Therefore, my next question is, if you are therefore
No,
able
my
to
lord,
ascertain,
just I would
yes,
like to. So those consumers who does not have any separate contract demand agreement, for them the connected load is converted into KVA, and that is considered as a contract demand by
okay,
default.
so irrespective of everything, a person will therefore, every consumer will have a contract demand,
Yes.
irrespective of you have an agreement or not.
For
But
high
if you
tension.
have an agreement, one thing good is,
For high tension.
no, if you have an agreement, one thing good is that you can lower your price taking into account your contract demand.
Hmm.
Just for example, this mostly applies in the tea industries, wherein during the months, the months from December to March, there's less of work. So they therefore say that during this period, my contract demand will be this much. Other periods, the contract demand will go high.
Hmm.
They may have this. This is being held in tea industries and all.
Yes.
Now, my question therefore is, if that be so, how did you ascertain that there was an overdrawal?
So as per the record, my lord, as per the recorded demand in the meter.
So therefore, you find out that there is an overdrawal on the basis of the meter.
So that overdrawal is, my lord, when the consumer, while consuming power, violates the contract demand agreement.
Understood. But you found out
Yes.
from the meter.
From the meter, yes.
If that be so, then why you are not in a position to find out every month? Then you are applying 12 months.
No, my lord, every month the RD is shown by the meter every month.
Yeah.
But that RD is no way giving us any idea of the total installed capacity of the
No,
consumer.
for that, you need to look into the connected load is another aspect. I'm not on that.
Yes.
But here is not a case of connected load.
My lord, it is the case of connected load. Unauthorized use of electricity is always related to the connected load.
You see, kindly see his order. Where is the order, Mr. Ria?
The formula 7.4.
Appeal under 137/27. Where is the appellate order? Yes. On examining the final assessment bill from so-and-so, it is found that the bill was prepared for the entire detected load of so-and-so at twice the rate for 12 months less already paid fixed charge for that period. The bill prepared as per the formula given in so and so is found to be inconsistent with the so and so. The assessment should have been made only on the excess detected load of 422.64 instead of 10 so and so. The assessment on unauthorized use of electricity by the appellant may be made as per 126(2) of the IMAN and found again a load found connected for a period of 12 months at double the rate. Now the question is, on what basis did the appellant authority come to a finding that you do it for 12 months?
First of all, my lord.
When it is not your case of the assessing officer that they tried to find out whether it is 1 month, 2 month or fraction of a month.
My lord, fraction of a month, that term has been used here as because most of the time when we are carrying out an inspection, we visit the premise suppose we have visited one premise on 12th of January or 15th of January. So when if we find out that during inspection that the connected load is the total connected load which you have found is more than the sanction load. So at that so penalty will be levied, that is decided on that particular day. So from 15th, of that particular month, so we will go back up to 12 months.
Why?
No, my lord, just let me complete it and after that I will, my lord. So we will calculate up to the up to 12 months or the actual date of occurrence if in case we are in a position to determine. So this is the fact. And my lord, in many cases we have found that this period has exceeded even 12 months. For example,
so therefore, my question is, isn't it required for you to put a note on that? That look here, we have found these are the basis on which, and it is more than 12 months, and therefore we hold it at 12 months.
That exercise is, my lord, done by the assessing officer.
So therefore, if he has not done it, can you have for 12 months?
My lord, if he has not done it, so there were not sufficient materials, or maybe sometimes it has been overlooked by him. It may also be like
So if that be so, because you see, if you are doing it for 12 months, you are multiplying into 2. The penalty is 2, twice. So you're multiplying into 2 and then subtracting it with the amount which he has paid. So if it is just for 1 month, then you are multiplying it into 2 for the 1 month and subtracting with what he has paid for that month, and that may be here. But if you are doing it for 12 months, the amount becomes more, unless you have justifiable reasons that this, we presume this to be 12 months for this has happened. Maybe for the last 12 months, just for example, you are finding the overdrawal. For the last 12 months, you are finding that there is an overdrawal. Yes, that might be a reason that for the last 12 months, this is an overdrawal, so we do it this way. That might be a good reason. That is not what has been applied. Then,
my lord, if I just want to add here one thing that suppose when we select one consumer in our lab, when we select one consumer that, okay, this consumer has to be visited because it seems like he has excess load. So we take this recorded demand as a parameter. So we, Your Honor, we check the HT consumers individually, and we emphasize basically on the RD. So whenever we see that, okay, this consumer is contravening the contract demand regularly, almost regularly, or in every 2 or 3 months. So we have a good reason to suspect that, okay, there are ample amount of excess load in the premise. Okay. So accordingly, Your Honor, we visit the premise. But this is just an idea. We can just take an idea that, okay, he might have some excess load in his premise. So based upon that, when we reach the premise and when we conduct the load survey in details, then only we can ascertain that actually how much quantity of excess load he has. So this is the thing, my lord.
No,
And
so therefore, you see, Mr. GM, you have to understand, this court is not on any other aspects, only one aspect. That when the regulations say that you can very well, you can impose this is the formula in which, and the regulation also says the numerical n has to be the month or number of months or fraction of a month. Meaning thereby, the regulations foresee that in a circumstance, the amount can be for a month or 2 months or 3 months or maybe whatever months, but it
Absolutely,
cannot
absolutely.
go beyond 12 months.
I agree. I agree.
So therefore, if you make the basis on the basis of the bills, wherein you find that every time there is an excess in his bills, which categorically show that for this period he has violated the contract demand, and it goes beyond that for this entire period, you can very well do so. And that may be the basis. And look into out here and come up out here and look here that these are the patterns which otherwise will show that if that is the reason why this has happened. And therefore, this is the total amount which can be used, because for the last 6 months, we are finding that this person concerned is having an more than the OD. What is that? Original demand. Yes. But he is using the MD. He's having it. So if you are finding that, on the basis thereof, you apply that 6 months, 7 months, 10 months, 12 months, or not more than 12 months. But if that exercise is not being done, can you say that this is proper?
I got your point. I got your point here.
That is the only issue. Because you see, that is why I said 126.5 is only in respect to restricting. Taking into account that, you see, there are many aspects. Just for example, certain aspects are given in law that you are restricted. Just for example, I have an amount to be paid to pay to you. You can claim the amount from me, but you cannot claim the amount after 3 years. There's a limitation being given by law that beyond 3 years, if you are entitled to the amount, if you don't claim it, then no, the law will stop you. Similarly, here 126.5 says you can. He may be violating for a long time, but you can't have it more than 12 months. When you cannot have more than 12 months, meaning thereby that it can be less than 12 months also. And if it is less than 12 months,
Can be more than 12 months. It cannot be a certain, then it will be limited to 12 months. 126.5 says that if the active period can be asserted, then it will be for that academic period. Yes.
that if the period of another cannot be ascertained,
Then
such period can be limited to a period of 12 months immediately preceding the date of inspection.
8 months. Then it will be 14 months. Because the first part of 126.5 says, if the assessing officer reaches to the conclusions, then unauthorized number of access taken to the assessment shall be but entire period in which such unauthorized number of access. So it
Entire
can be
period.
More than 12 months.
So therefore, there has to be a finding
There has to be
that
a finding what is
that
the period.
the period.
Yes,
Now, if you cannot find out that period, then it cannot go beyond 12 months. But if it cannot be beyond 12 months, it can be less than 12 months. So therefore, it has to be on the basis of some findings.
Your Honor, in this particular case, it is evident that in the year 2016, in the year 2016 too, they had to pay there was an instance where they need to pay the overdraw penalty.
Instances in fact.
Several instances.
2016 onwards, they have been imposed with overall penalties, man. I can place these bills. So it goes back to 2016. Well, considering what 126.5 says, my lords, we could probably, the assessment period could have been beyond 12 months in this case, my lords. It was restricted to 12 months. I can place them.
My lord, in that case, my lord, in every bill cycle, my lord, every month, my lord, they have inspected the meter and the meter has been recorded, my lord. What has been maximum demand has been recorded, and every month they have got it. And upon that they came, assess that amount, and accordingly they have penalized my lord as overdwell penalty, my lord. SGM had already stated, my lord.
That is my overall penalty, my lords. Is again, my lords, on account of violation of the contract demand, my lords. The contract demand, as far as the petitioner is concerned, my lords, will find at page 39.
My lord, contract demand, the overall penalty, the purpose of levying overall penalty is Bill.
So this overdrawal of penalty which is there is differing from annexure 15, 16, 17 and 18.
Yes, the amounts.
Amount is differing.
My lord, in that case, on 10th of August 2017, the authority has inspected the premises, my lord. On 10th of August 2017. So they cannot go beyond that, my lord, as they.
And
have-
at that point of time, they did not find anything.
No, my lord.
Then how can you have 12 months?
10th August court corporation. 10th August court inspection.
10th August 2017. No. We have done in the month May.
May 2018.
May
my lords.
2017.
18 is the inspection, my lords. Inspection as far as the assessment is
18,
concerned.
18.
Earlier inspection. Earlier inspection was on 10th of August 2017. Then they cannot say about 2016 or other years. my lord.
No.
So then they found everything okay.
Oh, yes, ma'am.
Where was that report?
For these 12 months, we have to interfere
Yes.
and thereby directing them to reassess on the basis of what?
This is of the recorded demand, my lord, recorded maximum demand.
Recorded maximum demand. Because at that point of time, now how do you apply this one? Mr. GM, let me also for the sake of everybody, let us find out another thing. Now, this is post amendment. There is again an amendment out here.
So do you have any report of inspection last inspection that you have mentioned?
Yes, what do you say about clause 7.2, Roman 3, B, AB?
MDI meter.
In case of connections equipped with MDI meter, no assessment shall be made for unauthorized extension over and above the connected load as per the agreement. Penalty for drawal in excess of the contract demand shall be levied at 3 times the normal tariff for the portion of the demand exceeding the contract demand.
Your Honor, this particular provision was introduced, I think, in the year
Understood.
2009.
And I'm saying now, this was introduced in 2017,
2019.
which 19.
19.
Okay, so therefore 19, now what is the effect of this? That means every month?
The effect of this is that, my lord, we can inspect the HT consumers, but we can inspect the HT consumers. Load inspection can be carried out, but we cannot penalize them just because we have found excess load over and above the sanction load. We cannot penalize them. So
For that 12 months. You cannot apply
yes, my
this
lord.
one, 7.4, 7.4.2, 3 capital A. Capital A, small a. You cannot apply this.
This is applicable only in case where the consumer does not have MDI meter.
Understood. So after a person has an MDI, what is an MDI meter?
Maximum demand indicator meter.
So therefore, maximum demand indicator meter, once a person has it, means all these meters nowadays are maximum demand indicator meters? No.
All the
Yes,
ST consumers, my lord. All the ST consumers are MDI meter.
my lord. Nowadays, every meter has this provision of maximum demand indicator. Every meter has this provision. Whether be it domestic, be it commercial, everywhere this provision is there.
MDI is there. So
MDI is
now nobody, so nowadays you cannot apply 7.4.2 Roman 3A small a,
Knowledge.
isn't it?
Yes.
In view of the MDI meters being
In
available.
extreme cases, my lord, where actually in rural areas still these mechanical meters, black meters in some consumers.
No,
who-
that is a different thing.
Yeah,
But normally all are. And those
normally all
prepaid,
are. No.
prepaid meters,
Prepaid meters also have this facility, MDI facility.
MDI facilities. So therefore that is only three times the normal tariff for the portion of, so that is only for 1 month, that month,
That is for only for that particular month,
for that particular, not beyond that.
not beyond.
Okay. So therefore, this 12 months direction has to be now looked into only in, at that point in time, you did not have an MDI meter. Then, but at that point of time, this clause was not there.
This
At
clause
that
was
point of
introduced, my
time,
lord, in
it
the year
was
2019.
different,
1970, because that lacuna has been come up before the regulatory commission. When the Simpex authority has filed a complaint, my lord, that order I have next year, my lord, where it has explained, my lord. Otherwise also, my lord, as per clause.
No, earlier, at that point of time, which was holding the field, your case happened in the year
2018.
2018, but before 2019. This is an amendment of 2019, na? Okay.
Yes, my lord.
So here at that point of time, demand charge in case of excess is excess demand is equals to 2 into C into B into N minus D. The excess load will be removed from the supplier means. However, the consumer may apply for regularization in case of death of the transformer or other appliance assessment in case of unauthorized use of electricity, change of category, resale. We are not concerned with this.
My lord, that is actually clarificatory one only. Because, my lord, when the Simpex has approached the commission by filing a complaint, my lord, the commission has analyzes the provisions upon the clause 3.2.2 and 7.4.2, my lord. Because 3.2, my lord.
3.2.2.
এইটো যে আমি সে এমেন্ডমেন্টৰ হেৰিটো এমেন্ডমেন্ট তাতে লিখাই আছিল এইটো বস্তুটো
Where is 3.2? Huh?
At page, my lord, 16 of this regulation.
New one.
New one, my lord, only that provision amended.
3.2.3.
3.2.3. 2.3.3.
2.2.3.
2.2.3.
2.3.
It looks conduct
2.3.
0.3.
Page.
তাতে লিখা
Page 16, my lord.
1.6.
One.
2.2.3.
Yes, my lord.
Okay, yes.
Here it is stated, my lord.
Contract demand, the contract shall be the LT consumers using maximum demand based tariff. The contract demand for LT consumers without maximum will be the connected load of the premises as per the agreement entered into between the consumer and the license, and LT demand with MD tariff, base tariff and all HT and so and so. Contract demand shall be as per the agreement entered into between the consumer and the license and have regard to the requirement of the consumer installation and will be independent of the connected load. The contract. Yes, what do you want to say?
I want to say that the contract demand may be the independent from connected load. Whatever may be the connected load, I can use up to the contract demand, my lord. And that contract demand, exceed or not, is determined by the meter, my lord. Because maximum demand is recorded in that metering system. my lord.
No, maybe it is there. So when you are going to penalize him, you are also going to subtract the overdrawal penalty.
Yes, as in the assessment bill we adjust the overdraw penalty which is already realized from the consumer.
So overdwell. So therefore, you are to find out the basis on which it is the period. And the only manner in which you can find out is by going into the overdwell penalty.
Penalty details.
The period for which there is an overdwell, continuous overdwell penalty, you cannot have for the earlier period. Can you have it?
For the earlier period, so it is already in.
If there is a gap in between, just
Yes.
for example, 3 months gap is there, then how do you take care of it?
Last month, the first month when he was encountered with such penalty.
Then after that he's not done, then you are going to have it for 12 months. Just for example, the 1 month he has done it in the month of January, then you catch hold of him in the month of December. And in
Perhaps,
between there is
Your Honor, I
nothing.
missed your point. I
Now, how do you take care of this period? How do you take care of this period?
This
Means from
assessment
which
period.
period? Yes, if there is a continuous period of these, you can very well do it. But if there is a gap, how do you take care of it?
Actually, Your Honor, while assessing a consumer, we do not rely upon this maximum demand parameter, because maximum demand only gives the data or indication of loads. That's why the extra load, we always, most of the time we emphasize on these details, that when the consumer has purchased these extra loads which have been found in the network.
So you will look into when he has purchased the appurtenance.
Yes, and if any installation report is there, so on that also we.
So that is another fact-finding inquiry.
Yes.
So therefore, you cannot apply. You see, just for example, in this case, you have not gone into that aspect. How do you take care of a situation? Because you see, what as of now it is being, you have the MDI meter, there is no problem with that, with this MDI, and you have this provision of 7.4.3 and 4.3 Roman 3 AB. There's no problem now. But at that point of time, how do you take care of that? Because this order may affect many other cases which are pending. So therefore, how do you take care of this aspect? You may think about it. Mr. GM, I am therefore saying, think about it, because this may affect many other cases which are also pending.
Last date of inspection also we take most often.
Now, understood. Last date of the year, but how do you have the first date?
Your Honor, if the meter does not have, because meter runs on the input, which suppose a load is connected to the meter, but it is not switched on. So meter will not be able to detect whether that load is even connected or not. When that load is switched on, then only the meter is able to detect that. So, and what is the, and my lord, what is the maximum demand? I would like to elaborate here. That the maximum demand is, suppose in this room, the total load counts to 10 kilowatt. So now I have put on some lights and switches, which counts to 5 kilowatt. And if that 5 kilowatt is continuously there in the meter for the next 30 minutes, then the meter will note down this the total amount of load which is used continuously for 30 minutes. So it will keep it in his register, that is 5 kilowatt. So suppose tomorrow I have switched on many lights and that now counts to 7 kilowatt. Now I have kept that light switched on for more than 30 minutes. It will again record it and it will replace that 5 by 7. So in this logic, it will go on. And in this manner, on the day 31st or 30th of the last day of the month after 12 p.m., it ultimately reveals the actual demand of the consumer, maximum demand, which he has used in these 30 days. The maximum demand which he.
So therefore, there is an indication.
Yes.
That there is an excess, unauthorized
Might be
excess
there.
load of electricity.
Might be there. So
there is an indication.
Yes.
So therefore, when there is an indication in the meter or in your bills, and this will be reflected in your bills, then in that basis you can do it.
Yes.
Against the unauthorized use of the electricity on the basis of the connected load. Because here you are doing it on the basis of the connected load. only for that period. But if there is a gap, my question therefore is, if there is a gap of 2-3 months, then how do you take care of it?
It means separate assessment. It may be separate assessment.
I did not actually.
How do you take care of that? If there is a gap, just for example, 3 months there is a gap.
I mean, don't get the point actually.
Mr. GM, you think over it. You think over it and let me know next step.
Sure, Your Honor, but I
It's
did not
always a-
actually get the actual point when.
No. I'm saying, just for example, 1 year is there. His assessment was done in the month of December 2025. Let's take an example. For the month of October bill, November bill, and December bill, you find out that there is an excess use of electricity beyond the contract demand. You find it. But for the month of July, September, or June, there is nothing. But again, for the month of March, April is there. How do you take care of that situation? My question is that. You get the point?
If prior to March, that means within this 12 months, prior to March, if there is no such exceeding of maximum demand, then I will take March as the benchmark.
How can you take it? Taking into account the fraction of the month is being mentioned. My question
Fraction
is
of, so in
N
this,
says the fraction of the month. My question is that.
I
Think
will think of this.
You think about it. How do you take care? If you can take care of it, very good. Very nice. Anyways, getting some money for APDCL is good.
Actually, Your Honor, this overall penalty provision is there just
Mr.
to.
JM, I have noticed out here, this 12 months is being applied mechanically. That is why I caught hold of this. Now it doesn't apply. But at that point of time, I have seen many cases where 12 months is just applied mechanically. Here also, if you see the appellate order, that for the next 12 months on 447 kilowatt, he will be charged. What is the basis? The appellate court did not find out that these are the period where it is there. How it is being assessed? That is the issue. When you are convenience, but don't make it long, otherwise I forget.
No, Your Honor, actually this overall penalty provision is implemented for maintaining the grid discipline. Because if suppose based upon the contract demand or the sanction load, we ascertain the total demand and we also have to purchase power from outside. So if these incidences of overdrawal increases, then it put pressures on the grid. And if the grid collapses, then
Mr. GM,
everybody
I
will suffer.
understand completely.
Yes, sir. Yes, Your Honor.
That I think you should also give a credit to me. I understand.
No, absolutely,
There's no
absolutely,
quarrel
Your
with
Honor.
that.
I'm grateful.
My only worry is, can you mechanically apply 12 months? My only worry is this.
No,
Because you are applying twice and thereby doing it. There has to be application of mind. Yes, because of these 3 months or 4 months, we found that there is an overdrawal penalty. And another question is, if the overdrawal penalty is different, can you just mechanically apply that for all these things? Because just for example, I'm saying, annexure number 15, you will see it is 446. Annexure number 16, you see 502. Annexure number 16, you see 402. Now, what is the basis? How do you calculate this? Or just mechanically say that there is overdrawal, so we take it? Or it can be, yes, you cannot go to so certain macro things, so micromanagement may not be possible. It may be thing. But then also you cannot, this is too macro, to the effect that this particular period, you cannot have it like 12 months mechanically. Move particularly in view of this.
No, that is true. That is true.
Chalo, I've understood.
And that even mean that it is a sort of connected load is different from this.
Huh?
what is stated about the connected load, my lord, definition is defined, my lord, because that is simultaneously used.
Now understood, whatever may be, there is a connected load. If the connected load which is there, it will be presumed, if there is an excess use of load, it will be presumed that there is a load. Certain micro things cannot be looked into. Just for example, as I say, 15, 16 and 17 and 18 says about the difference. One is saying 442, one other is saying 402. This micro cannot be that. So certain advantage can be given, have to be looked into. But on the other hand, the question is, if it is being found on the finding of fact that there is a connected load of 447 kilowatt, this period, this for connected load has to be multiplied by the whatever it is to the tariff which is there. And then for the particular period only. Only thing, Mr. Saikia, is on the period. Now, if it is the period, if they can very well find out that this preceding the particular month of inspection, this was the overall which had been made by you during this period in the bills, then very well, they can have it.
They can.
And if they can, as Mr. Pathak has also said, if it goes for last 24 months also, they can, but they have to ascertain. But ascertaining here can be done for 3 months. But how do you take it if there is a gap period of 2 months? So that is it. Anyways, Mr. GM, we have been very thankful for you for explaining it to the court.
I'm really grateful, Your Honor, that you
Yeah.
have patiently listened to whatever
No,
submission I
these
had.
are very fine tuning. So only thing is why I'm a bit more concerned about this thing is this matter, any observations made will also affect many other litigations. So therefore, and more particularly some litigations are also ongoing in the under 127. So therefore, this I'm giving you another chance to look into it. How do you take care of this situation? So and so, Mr. So and so, the GM, General Manager.
No, Your Honor, DGM, Deputy General Manager.
The DGM APDCL. It's DGM what? Anything?
Commercial.
Commercial.
Commercial and revenue.
Commercial and revenue. APDCL is present. And he had explained to this court as regards the various parameters, how clause 7.2.4.2 Roman 3.1a 1 applies. Full stop. This court, however, inquired with so and so, the learned DGM, the DGM, no, not DGM. As to how the period that is the numerical, that is the variable n can be ascertained by the assessing officer. As whether it is on the basis of the monthly bills which is being provided to the consumer, wherein there is an overdrawal penalty, and for how long, and whether it would be permissible to take into account if there is any gap period in the bill so submitted to the consumer to calculate the entire period. The hearing, however, remained inconclusive on the said aspect. Accordingly, this court fixes this matter again on when can you come? If you're busy.
As per your convenience.
No, no, you say convenience is obviously there. Yeah. I am always at the convenience for everybody, but the convenience has to be also of the lawyers. Lawyers, you know, Mr. DGM, they are more busy. Yes. Can we have it on 12th? 12th, no, 12th, possible 12th, second half I am sitting.
10th, if possible.
10th. 10th, possible. 10th, Kimanta matters, both matters. 10th. Oh, no, 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 no. Already 18 matters are there, not possible. This will take some time. Oh.
13, 14,
Alternatively, my lord, sometime later, my 13th if possible.
13 not possible, it's a Friday.
It's a
Nah.
Friday.
You may convince your fellow councils that no motions will be moved. If you can do that, very good. Okay, we have it on 5th of March. In the meantime, you put a written note. Okay. So that we can pass the final judgment on that date. 5th of March at 2 p.m. Anything more? Tempering. So his case also, let him also be satisfied that till the next date, nothing is happening. Case will be dismissed, so.
Deeply.
5th. Actually, I'm not sure whether I'll be here for the week commencing from 16 to 27. That is the problem. I'll get it to know within the 2 days or so. But anyways, don't put the date. If I am there, I'll inquire with the officer, and if I'm there, then I'll put it on 19th or 26th February, if I'm there. Otherwise, it goes to 5th. Oh. Mr. Kakuti, don't you think that the matter has been substantially heard by Justice Soumitra Saikia?
Once heard, Lordship, but it's
On
not kept
4/12,
bottom.
2025, it seems that he has fairly heard the matter.
Lordship.
And he's only asking for some document, only one query has been made.
Lordship.
And therefore submit that a sufficient time be granted to reconstruct the construct. Accordingly, let the council appearing for so-and-so place before this court the relevant materials as directed on the next date fixed on so-and-so. It would be necessary for the respondent to place before this court the relevant materials to show that pursuant to the increase in quota for promotion at the relevant point of time, only the posts which are subsequently filled up by the private respondent number 7 was available and no other posts were available. So and so appearing therefore submits the area. He has taken into account. What do you say?
Lordship.
Oh, some file got lost.
Lordship. The original file was lost, they have reconstructed it.
You have discussed.
Yeah, yeah.
Must be because of a judgment be CAB.
Yeah,
Huh?
yes, it was.
Ah, yes. Okay. 2/4/2024. And it was on 11/8/2025. It spoils the reputation of our court. What are you challenging? Let me finish. All matters are so much urgent, every matter should not be set aside and quash the recommendation of the DPC in pursuance to the internal advertisement so far as it relates to the same relates to the selection of additional vacancy to the post. So you've got a reconstructed file.
Yes, Lordship. I will.
We take it up on some other day.
As your Lordship pleases.
It is not required to be put, because if you see, if I put it to him, it may not be that he wanted this matter to be kept as part heard. It may not be proper. There's one matter I am having it with me that would didn't make it part heard, but there's an order passed by the coordinate bench putting it to me. So therefore now it becomes very difficult for me to recuse myself from that.
Understood.
So taking into account that I am a victim in this regard, so I should not make somebody else a victim. Anyways, so we'll have it when let's try our luck on 17th of February if I'm there.
Please.
Due to paucity of time, the matter could not be taken up. Taking into account that the matter is of the year 2023 and the matter requires an urgent disposal. List this matter on 17th of February 2026 for final disposal. Liberty given to the parties to mention the matter for upgrading. Mr. R.P. Kakoti, the Kalani Senior Counsel, you're assisted by
AB Day, my lord.
Mr. So-and-so, the counsel assisting Mr. R.P. Kakoti, appearing on behalf of the IIT, shall place the records on the next date.
Lordship, obliged.
The reconstructed records.
We've done it, Lordship.
No, it's a reconstructed.
Reconstructed.
The reconstructed records.
Lordship. Obliged.